they hear the word. Okay, so today we're going to talk about a lot of those things about IRAs that are more complex. They're one of those situations that you deal with regularly, but you need to know a lot of information about in order to be able to process them. I love that I just saw someone today as their first day in about 10 years. That is awesome. So glad to hear it. So whenever we're dealing with IRAs, remember that we have a lot of different things we need to do in regards to them. Mostly you're talking about opening those documents. That's a big thing that you deal with those IRAs, as well as you also deal with the fact that you are going to have beneficiaries that come in eventually. You're going to have to know how to handle them. And today's course goes over all of those things in particular. The rundown is going to be pretty similar to what it was yesterday, and that we're getting started here at 9 o'clock. We're going to try and get through the first 1.5 sections there before we do a little break, a 10-15 minute break, depending upon how everyone's doing. Then we finish up the next 1.5 sessions there. And then from there, we're going to take a lunch, probably around 11:30 to 12, and then finish up with the final 3 sections. The booklet that you have is pretty similar to what you had yesterday for those of you that were here. For those of you that weren't, note at the very front of it, you have an IRA, or you have a table of contents. It lists what exactly we're going to go through today. It tells you we're starting with IRA updates, all things, the rules and regulations that have changed recently. And then we're going into amending IRA documents. From there, that's going to tell you exactly how to amend those documents to make them up to date with those current law changes we just talked about. Then we've got RMDs, required minimum distributions. I'm sure everybody's favorite topic there because you deal with it regularly. Then you have beneficiary options, which is another favorite. We always like to say when people call into the IRA consulting lines, you might as well say, "Good morning, my name's Elena. Who's passed away?" Because a lot of the time, those are the questions we deal with whenever we're talking about IRAs, is how they're to be handled after death. The final 2 sections, we have advanced portability, which goes through exactly the movement to and from IRAs, how those things work. And then the last section, we've got a new section that's about finding answers to commonly asked IRA questions. So this is a very important section. It goes over that information about the questions that you might get asked very frequently, but are a little harder to know exactly what to say to those customers when they come out about them. Then you have a job aids section. This is my favorite section, just like it was with the essentials. It goes over all of those great charts that you might need. A lot of reminders of things are in there. It's very handy to keep on file on hand really close to you. That way you can always refer back to it whenever you're doing things in office. The last 2 sections, you've got the glossary. Pretty much exactly what it sounds like. It's the same glossary type you're dealing with. You can look up a word, see where it's at in that area there. And then finally, we have the exercise master there. That exercise master is going to give you all the answers to the questions I'm asking you throughout the webinar today. Remember, try and not use that exercise master until later. Work on just looking at the stuff you have on hand and answering the question with your knowledge. Why? Because your answers help me know how to teach from there moving forward. If you're giving a wrong answer on something, that's okay. I'm okay with that because that means I know I need to go into more detail on that section. So I would rather you all answer and give a lot of wrong answers than not answer. So remember, you can verbally give those answers, ask those questions, or you can chat them in on that chat feature too. So that's what we're dealing with the table of contents there moving forward. What I would like to start with is, just because we're dealing with a lot of things like the updates and amendments. I just want to ask a question to get to know you all, to kind of see who's going to be paying attention to what part, who's the most interested in what part of this section here. So whenever you signed up for the IRA Advanced class, when you knew what we were going to be talking about, what was the thing that excited you the most? Was it the RMDs? Was it hearing about beneficiaries? Was it just learning the new rules? What excited you the most about this course? Beneficiaries? Yeah, that tends to be everybody's thing. RMDs and beneficiaries, the new rules that came out. We've got commonly asked questions and advanced portability, new beneficiary information, updates for the new rules, beneficiaries and updates. Good. So, like we thought, on the census lines, mostly a lot of people are very interested in those beneficiary things. And I'm sure it's because you get asked those questions regularly, right? So now that the rules have changed, you want to know exactly what's going on with those. We have a really good section here on the beneficiary options that goes through all those new options, the previous options, and we explain a lot of those new rules there in that. Remember, you can always turn on your camera. I do appreciate that. I can get to see you guys and see your beautiful smiling faces. If not, if you're working from home or doing something like that and don't want us to see your jammies, that's okay. I understand that too. So we're going to go ahead and hit the ground running here though, and start with that IRA update section. Are there any questions before we begin? So our IRA update is going to be those things that have changed recently. You should see now the IRA update screen. Everybody see that? We're about to move to learning objectives, so you should have changed 2 screens now. So I think we are connected and good to go here today. Finally, we got those kinks worked out, right, guys? So after completing this section, you'll be able to explain recent changes affecting IRA owners. So all those recent rules and regulations that were passed, Secure Act, some of the things you're dealing with CARES Act, different things like that, how it affected IRAs, what it affected beneficiaries, IRA owners, everyone in regards to those IRAs, and recognize how recent changes affect your financial organization too. So what is now going to be expected of your financial organization because of these laws and rules and regulation changes? We're going to go through all of that information in that IRA update section here. The first part here we're going to talk about is the IRA Amendment Guidance. So what happened with the IRA Amendment Guidance? Before we do that, I want you guys to chat into me. Do you know where you get your IRA documents from? Chat it in or talk over the speaker, that works too. Tell me if you know where you get your IRA documents from and what document provider do you use?
Colin Fritz.
Colin Fritz, okay. Do too, okay. Anyone else? We've got a Wolters Kluwer, Colin Fritz, CSI. Walters, okay. So this is something you will want to know. If you don't know this information, you're going to want to find out this information. That's your homework for today, okay? So make sure you know that information moving forward here. Why is it so important? Because different documents are handled different ways, and we have to do different things with them. The important thing to note is that recently we have received some guidance from the IRS. It's called Irs Notice 2020-68. And what it tells us is that because of all the recent law changes through Secure Act and the other law changes that have occurred recently, we are going to be needing to amend those IRA plan agreements and disclosure statements for those Secure Act changes. What this means is that our documents, If you use model documents, not a prototype, which is a lot of people use those model documents, come straight from the IRS with that exact wording from the IRS, then you haven't updated your document since 2002. And that's a plan agreement. Now, you might have updated your disclosure statement more recently, but the plan agreement wouldn't have been updated since that 2002 time period. Why is that important? A lot of changes has occurred. So because of that, we are now amending those model documents through the IRS. They're telling us we're going to do it by that 12/31/2002 deadline, or 2022 deadline, or a later date determined by the Treasury Secretary. Notice they've already given themselves a little loophole to get out of that 12/31/2022 deadline, because as with all things with the IRS, things get held up based upon new laws and regulations that come out in the middle too. So at this point in time, we're expecting it by the end of the year, but that doesn't mean for sure it will be the end of the year there that we're required to amend. If you use a prototype document, that would be a document where you get to add a little bit of customized language there. You're going to use what they're called as a listing of required modifications to update that. They may have been updated a little more recently with those prototype documents, because that listing of required modifications has been updated more recently, so they could make those changes. It's important to note that we'll talk more about this here later in the course, but at this point in time, just realize that that deadline is set for the end of the year. With that, we need to send out our amendment to all existing IRA customers, as well as update those applications, those forms, anything you use that would have been affected by those law changes. So there's going to be a lot of updating and a lot of changes that need to be made moving forward. Withholding requirements is actually a new thing that has recently changed. Why has it changed? Because we're now dealing with a couple different forms. This is something that is, like I said, very recent. It went back to, we just started having new guidance on this in September of 2020. So one of the things you need to figure out whenever you're dealing with withholding is what type of a distribution are you dealing with? And that helps determine what requirements are going to move forward here. So we have two types of distributions. The first one being a periodic distribution, and the second one being a non-periodic distribution. This used to confuse me because of the way they're worded. To me, periodic means it just happens regularly, right? We think, okay, quarterly or annually or something like that, but regularly. This isn't exactly what periodic distribution means. It actually means it's talking about those annuitized distributions. So distributions that you have a set payment you're required to do every year or at a certain time period, and you are required to do that amount no matter what. You can't change it. You can't do anything differently with it. It's treated as wages for determining withholding, and you use the income tax withholding tables with the assumption that you are a married 3 exemptions rate, unless you elect a different rate and or choose not to have a 10% withheld there. Now, in September of 2020, the IRS issued final regulations on the default tax withholding rate for those periodic annuitized payments there. The final regulations they did eliminate the fixed default of married with 3 exemptions formula. In the absence of a withholding election, that default would still apply, but it will be instead determined under the rules prescribed by the Treasury Secretary. The final regulations specify that rules and accompanying procedures for future years, periodic distributions will be communicated in applicable IRS forms, instructions, publications, or other guidance. They are also noted that for 2021, the withholding rate on periodic distributions, when no election is made, will remain unchanged. So will be applied as if that recipient is married with 3 exemptions there. What does that mean to us dealing with the IRA world? Honestly, nothing you need to worry about unless you deal with those annuitized distributions. Most of us don't deal with those. Most of us deal with those non-periodic distributions. And when I say non-periodic distributions, I don't mean that it doesn't occur yearly, because the person will have an RMD that occurs yearly. They set up that regular payment, right? We think of those as periodic, but it isn't actually considered periodic according to the IRS terminology. Those non-periodic distributions, what they mean is that they are payable on demand. We can request a distribution of any amount at any point in time. We can always ask for more. We can always even ask for less. It might just mess us up in the long run, with those RMDs, but we can always get our money from those accounts. Those are the non-periodic distributions. They have always been subject to a 10% withholding rate if you don't make an election. So if no election is made, we're required to withhold 10%. You could always elect to waive withholding or request additional withholding. It is important to note that these non-periodic distributions are what we're going to be dealing with IRAs for the most part. Those are typically what you deal with on a regularly basis. So why is this information important? Please excuse me with the breathing today. The baby must be sitting a little weird on my diaphragm here. I'm like struggling to breathe. Sorry, guys. But we do have different requirements now for us for that withholding option. We have to let them know if they're going to have $200 more in aggregate of those distributions, then we have to provide a notice to them telling them that they have the right to waive withholding or to elect a certain withholding amount. We are required to withhold, as I mentioned, at 10% from those non-periodic distributions if no election has been made. As mentioned before, this is a means for a person to prepay those federal taxes. For those of you that were with me yesterday, remember I talked about a little piggy bank with the IRS. So when an IRA owner withholds, it's like we're sending the money to the IRS to keep in this little piggy bank for us. They don't access that piggy bank until it comes tax return season. And they crack it open and all the money comes out. What they need, they take out. What they don't need, they send us back in that tax return. They need more, they request more from us. So withholding is a way to put money aside specifically for that time point to where we make sure we have that paid at that point in time. Some people may not be in that high of a tax bracket. They may not want to withhold that much. Others may be in a higher tax bracket, or they know they have a lot of taxes coming their way. So they kind of prepay for that and change their withholding amount according to that. Withholding is required to provide this notice no matter what age you're dealing with of that IRA owner, no matter if they're over 59 and a half, no matter if they're a beneficiary, no matter what, it is required. Don't confuse this with that 10% early distribution penalty fee. That only happens when you're under 59 and a half. Withholding applies to everyone, no matter the age. And remember the difference between withholding and that early distribution penalty. Withholding, we collect. The early distribution penalty, we do not collect. So our withholding rate here for years and years and years, maybe always, our withholding rate on those non-periodic distributions has always been the green area here, okay? We've always dealt with you either elect to withhold 10% to 100% or waive withholding. There was no in between. You couldn't elect 9, you couldn't elect 3, nothing like that. It was you were always required to do this. You would do this on that W-4P form or substitute form that looked like the W-4P form. For example, our census documents, we have our distribution form itself has a little extra section that has the W-4P information on it, where you make that election and it's required to do 10% or more or 0. What occurred recently here with that changes, those changes that we're talking about, is we are now dealing with something also known as a W4R. For 2023 moving forward, we are required to use the W4R for non-periodic distributions there. The W4R actually shows that you can elect 0 to 100% for non-periodic payments. So this is a huge change in the IRA world. It is on the final form at this point in time, so we do think it might be moving forward. It is something that might still change because maybe they realize that they didn't have it changed to only show 10% to 100%. But we do think the reason that they're heading in this direction is because simply that some people might fall in that lower tax bracket. And while they want to withhold some, you don't want to withhold the full 10%. It's not going to help them. They know they're going to get that back. So they'd rather just withhold 5% or something like that, or 8%. The other big thing that you're dealing with is the form no longer includes a checkbox actually to waive withholding. Whereas on the W4P, we always had a checkbox where you could just check and say, I want to waive withholding. I think they've made it a little harder by doing that. It seems like they don't want people to waive it completely, almost, by doing it that way. Instead, if a person wants to withhold, they would just have to enter 0 on line 2, letting them know that they want to waive withholding completely. Just like always, if no election is made, 10% is going to apply. Remember, these withholding elections do go forward with them until they change that election. We must always withhold 10% on amounts that are going to be sent outside of the US. So this will always apply for that 10%. They can't get out of that 10%. And if it's an eligible rollover distribution coming from a qualified retirement plan, we're going to be subject to that 20% or greater for the distribution. So these are all important things to remember. The W4R, the big thing that it changed there is that you might be able to elect less than 10% moving forward. Now, I mentioned earlier that 2022 was originally when this W4R was supposed to come into effect. They have now the W4R out, but they're not requiring it there until the beginning of 2023, at which point you will be required to use that form. Financial organizations must withhold on distributions where the financial organization has not received a withholding election from the person. Remember, once that withholding election is made, it's valid until revoked or changed. You always want to keep a copy of that election on file. That way, if someone asks, well, where'd this part of the money go? You say you chose to withhold at this rate. The IRS has it in their little savings account. They'll get it back if you don't need it, that kind of thing. Here's the W4P versus the W4R that you're dealing with. Notice the W4P has a lot more information that you're going to be filling out. As I mentioned, the census has always used a substitute W4P with their documents, their distribution forms. So you could do that on that. With either one of these documents, the individual can revoke a withholding election by completely filling out a new form and signing a new form, noting that information there. For periodic distributions, you're using that W4P. Think W4P periodic. That's what you're moving forward with that. I think W4R, IRA, kind of thinking it in that sense, a little way to remember which one you're going to use. Now, the periodic distributions, they have to include a line where the individual can show the number of allowances, a line for marital status, a line to ask for additional amount to be withheld, and a space for that signature. The W4R, like I mentioned, shows up here in the section. Let's see if I can get this. Shows right here, 0 and 100% on line 2. So it does show that you can do that for non-periodic payments at this time. All payers will have to update to allow for this. So in other words, financial organizations for years have programmed their systems to automatically deny a withholding election that is between 0 to 10%, right? Now we're going to have to update our systems to allow for this information, to allow us to provide that type of withholding election due to this form. It also means that all the forms we have noting you can't do it, they have to be updated. So notice you guys are seeing a trend here. There's a huge update process coming in all of our futures. That's going to, I'm sure, stress everybody out a little bit, but hopefully your forms provider can make it a little easier for you there. As I mentioned, there is no longer a spot to say, I want to waive withholding. You can no longer check a box that simply to do that on that W4R. So, any questions on that W4R and W4P there?
Just to clarify, does that mean that on a regular IRA distribution, like an RMD, let's say the client takes 12 equal distributions throughout the year, A, that's periodic, and B, you cannot, or I'm sorry, A, it's non-periodic, and B, you have to withhold 0 or 10% and above. You can't do less than 10 on those RMD distributions?
That was the way it used to be, correct. Now with this W4R, it is allowing for you to do between 0 to 10%. Unless something changes on this W4R, which is still a possibility because, like I said, they're not enacting it fully until 2023. I do know changes have been made in the past. I would think of this as pretty solid guidance that it is going to be allowing for it at this point in time, which means on those RMDs, even though they are taking it what we consider periodically, what we consider regularly, they're still called non-periodic payments, which means we will be required to use the W4R moving forward, and they will be allowed to do 0 to 100% at this point in time. Question W4R form to waive. Do you enter 0% in box 2? Correct. Because there is no longer a checkbox to waive, we have to enter 0 into box 2 to let them know we are not doing any amount. Another important thing that brings up is that it does say this has to be a whole number. So we can't do a decimal, we can't do a half a percentage, we can't do anything like that. It has to be a whole percentage there that we're listing.
What if a client prefers to have a weird hard dollar amount that ends up being a decimal?
Well, they would need to figure out how it's going to go into that percentage amount, because this form is very specific in that, unlike the W4P, how it used to be where I would allow for a dollar amount, it no longer allows for that at that point, this point in time. So they have to have it as a percentage. So if they were to put in $1,020, you know what I mean, that kind of thing, a dollar amount, it wouldn't work because it has to be a percentage. So it wouldn't be valid. Great question. And that is something a lot of people do. A lot of people are like, you know what, I want $100. Well, they need to figure out, okay, your RMD is typically this amount. What percentage does that account at? You know, what percentage is that going to be? Great questions. One other thing, if you're dealing with an in-kind distribution and it's not directly rolled over or transferred, any cash that is paid in the distribution must be used to satisfy the withholding on the in-kind distribution. If the distribution consists solely of property, no federal tax withholding is actually required on that, which is different, you know. So, question is, so in 2023, it will be required to have a W4R on file if we are performing distributions for our clients. Correct. You're exactly right. You will be required to have that W-4R available for the individual to fill out. Any form that you have a distribution on where it has had the W-4P, you'll need to change that W-4R information. And I'm sure they'll come up with a little information too on exactly what to include on those substitute forms, just like they did for the W-4P, where they said, you definitely need to have this number, you need to have this information. They'll do the same thing for that W-4R too. So I'm going to keep moving forward here. If y'all have more questions on that, go ahead and ask them. I'll stop and we'll go back to something if we need to on that. I'm sure some of you have already experienced questions on this because we are already in 2022 now. As you know, in November 12th of 2020, the IRS published final regulations noting that the single life expectancy table will be changing beginning in 2022. How does this affect everybody? Well, it's not just a single life expectancy table that changed. You also have all of the other tables that changed. This was something that needed to occur because it had not been updated since 2002. So we've been using the same life expectancies for all of this time. Naturally, well, I guess we hope that naturally, our life expectancy has increased over these 20 years here. And the IRS is trying to account for that fact. So what they're doing is by increasing the life expectancy, that means that you're going to have to take less out of your IRA. That way your money lasts you longer there in that IRA. The date that this would need to change is going to be January 1st, 2022. So that means all RMDs figured out for the 2022 year will be using this new life expectancy table. And that doesn't really affect those because we always look back at that table yearly for those RMDs. So it's not really very hard for those IRA owners to have that updated. What is hard is for those beneficiaries that have regularly been taking payments. For those of you that are familiar with beneficiary distributions, if they were allowed to do single life expectancy tables or single life expectancy payments, what typically happens is that you're going to be dealing with, you look at the table in the year after death, and then every year following, we just subtract 1 from that number. So we never have to look at that table again. What this guidance allows for is it's called a transition rule. It allows a beneficiary to use a one-time reset where we go back to their original year after death and look at that number on the chart in the new life expectancy table, and then reduce by 1 for the number of years that have occurred since. This is something that we will go over in more detail, where I'll show examples and everything like that in the beneficiary options section. So don't worry if you're still confused about that. We will go over more detail later. Is it required to do this one-time reset? It is not a requirement to do it. It is helpful for your customers because they're required to take out less money. If you keep it on the old tables, they're going to have satisfied that requirement of the RMD amount that they're required to take by more than enough, because they'll be taking out more than is actually required of them. So it is very helpful. Now, those IRA owners, you're definitely going to want to have switched those new tables for those RMDs for 2022 on.
I have a question.
Yes.
Are those tables published yet? I tried looking recently and I could not find them on the IRS website.
Yes, and you gotta love how the IRS actually does their website because they're hidden. I swear everything you deal with on the IRS website is hidden in some manner or fashion. But they are now actually even in publication 590B and the new draft of that publication 590B. My suggestion, in order to get to it the easiest, either the draft publication 590B or just the actual rules, would be to go to the link.acensus.com and then hit the search button and type in life expectancy. And by doing that, and I might be able to actually show you that here real quick, if it'll let me. Is everybody seeing my screen right here? My web browser?
Yeah.
Awesome. So type in thelink.acensus.com. You hit the search button in the top right-hand corner. Type in life expectancy. If I can type. And you see this one here, it says updated life expectancy tables to be used starting in 2022. You can click on this final regulations button. That takes you to the govinfo.gov page, which is the official page that actually changed those life expectancies. I'm going to show you what they look like though. They're not very user-friendly, right? I think they look a little harder to read than what we're used to dealing with. You can see the information though. If you'd rather have publication 590B, I think it's a little clearer. And you just want to type in publication 590B draft. And you click on that first one. And this link here will take you to the publication 590B draft. And you scroll all the way to the end. And I think these are a lot more user-friendly here that you're dealing with. It's where they're easier to see and understand.
That's great. Thank you.
You're welcome. Any other questions? All right, now on to amending IRAs, that big question that's looming over everybody's head right now. Well, we've talked about all these rule changes coming. How do we make sure that our documents are compliant moving forward? We're going to talk about in this section the recent amendment guidance, what is required of us. We're going to define the plan agreement and disclosure statement amendment procedures. We're going to describe what a catch-all amendment is. What exactly does that mean? What does it include? What are we required to include with a catch-all amendment? And finally, we're going to talk about the amendment needs for mergers, acquisitions, and forms provider changes. So really anything and everything you need to know about amendments is going to be in this section. All right. Our recent amendment guidance that we have received is talking about the information we first started talking about in the update section. Model document was last required with a mass amendment back in 2002. So we're looking at almost 20 years that we're dealing with here, where we haven't had an amendment to the model document. What do I mean by model documents? So let's talk about that in a little more detail to make sure everybody is clear on that. The IRS develops what they call model documents. It's what people should base their form off of, base their IRA plan agreement off of. If you use the IRS model document, that means you're accepting everything the IRS said wording-wise, and you move forward from that. You'd be talking about using the 5305. The 5305R, things like that. Those are ones that you use that model plan agreement, which means you don't make changes to the rules there. You go with exactly what the IRS said. When I talk about they have not been updated since 2002, that's what I'm referring to. So the IRS lays out, this is what I want you to have, and they haven't changed it since that time period. It's a long time where a lot of law changes have occurred. A lot of things have happened. The prototype agreement is going to be something where you take that model document and they make certain changes to it that are allowed. Or they just use the listing of required modifications, things that need to be listed in there and they base their document off of that information. So there are certain things that are required to be in that document. They have been updated in more recent years, in 2007 and 2010. Now, they were required to be amended also in 2002, but they have been updated more recently based upon those listing of required modifications. So those would be closer to the current rules than your model document. When you're looking at your model document at this point in time, and like I mentioned, you need to know who your forms provider is, so it's going to determine what they have done from there. Most people knew that we were going to be requiring this mass amendment coming up. So what they've done is we've updated our disclosure statement to show that information of the recent law changes and not updated the plan agreement, because you can't do that without an amendment from the IRS. So in other words, your rules are going to be slightly different between the two. The disclosure statement's always probably going to be the more up-to-date information, because you're allowed to change that without the IRS saying you have to change it. In 2020, we did receive Irs Notice 2020-68, stating that plan agreements and disclosure statements are going to be required to be amended for the Secure Act. Because of the significance of all these changes in the Secure Act, they are saying that it is going to be a requirement that it must be done by December 31st, 2022. Or again, like I said, they made that little loophole that gives them extra time if they need it. December 31st, 2022, or a later date prescribed by the Treasury Secretary. What do we think will actually happen? Do we think it'll be done by the end of the year? I'd have to say, for a while there, they were waiting on making that model document until the Build Back Better Act went through, because it had a lot of changes that might occur to IRAs. Now that act is kind of not really applying much to those IRAs, but we are expecting further clarification and further guidance on the actual Secure Act, and some of those things were missing on it. And that's supposed to come out prior to the amendment. Therefore, they would need to include the guidance that they developed in the amendment. So at this point in time, December 31st, 2022 might be a hard goal for them to reach, especially with everything going on in the world and everything that they're dealing with. But at this point in time, that is when they're requiring the amendment. But in order to do this, as you know, you need that model document from the IRS updated. So you can't update until they update. Go ahead.
Is the onus on updating these documents for accuracy, is that on the document provider, like all of our outside providers, or is that the financial institution's responsibility?
So they would need to update the documents, but you would need to make sure you provide the documents to your customers. So you would have to not only give it to new people moving forward, but you'd have to make sure you sent out that amendment to everybody that is your customer. So kind of a combination, I'd say, on that.
But the language and all that stuff,
Correct.
that comes from the provider, that's on them.
Correct. Yep. They would need to make sure that it is accurate following there. You're exactly right. The documents that will be affected by this amendment, you're going to have those IRS model documents and the prototype IRA documents. Those are going to be affected by this amendment. Because our plan agreement documents, our plan agreements are going to be affected, this will also affect our disclosure statement. So we need to make sure that that's updated as well. Even if we've already updated it, we might have to change that disclosure statement slightly again to make sure it matches that model document changes as well. So why are we updating this? What happened that significantly changed things in the Secure Act? Well, with our amendment, we're going to be adding things, noting the information on this slide here. The first one being that there are no longer age restrictions on traditional IRA contributions. We are now allowed to make a traditional IRA contribution at any age, as long as we have, does anyone know what? What's our eligibility criteria for traditional IRAs?
Eligible income or earned income?
Very good. Yes, earned income. As long as we have earned income, we are able to contribute to a traditional IRA now at any age. Okay, eligible compensation. We have that. We have that active income.
As long as you're 18 or older, or
Any age. So traditional and Roths, they have no minimum by the IRS. Now, what might happen is you might have state regulations that dictate that you have to have an additional parent or legal guardian sign on that IRA if you're under the age of 18 or age of majority according to your state. And that does vary according to state law there. Great question. The other significant changes dealing with those IRAs is the Rmd Age Change. We are now going to have a later Rmd age, meaning we are required to take those minimum distributions at a later age. If you turn 70 and a half before 2020, you're required to use that 70 and a half age. If you turn 70 and a half after 2020, we get to start at 72 for those required minimum distributions. Remember, this affects those traditional and simple IRAs. Roths don't have an Rmd, so we don't worry about that with them. The next huge change we're dealing with is going to be that more rapid beneficiary payouts for beneficiaries. In other words, we have to take those payments out quicker than what we originally did. Why did the IRS do that? Well, think about it. The money sits in that IRA, still in that tax favored account. They're not getting their part of the money. They want to get their part of the money. Therefore, if they get the money out of that IRA quicker, they get their money quicker. So it's one of those things is, they want to get that money as soon as they can. Now, there are some exceptions to these rapid beneficiary payouts, which we'll go through here in the beneficiary section. But it is important to note that they do have, for the most part, a lot of beneficiaries are required to take payments sooner and get the money out of that inherited IRA sooner. Penalty tax exception. This was for a qualified birth or adoption penalty tax exemption. This also allows for repayment of this type of distribution. At this point in time, and I don't think I mentioned this yesterday, but we talked about that you could take out $5,000 for each qualified birth or adoption there. You are also allowed to repay that amount over whenever at this point in time. They do not set a time period. Most repayments are kind of stuck to that 3-year period. This is something we kind of expect them to give more guidance on. But at this point in time, they're not specifying that you have to do it within a certain time period. You can just repay that $5,000 at any point in time.
so those types of events, it's not really a distribution. It's kind of more or less a loan. You have to pay that money back.
You don't have to, but you can. So it's kind of like a rollover in that sense, except you're not subject to that 60 days. Does that make sense?
Yeah, I'm just trying to figure out why you'd want to repay it.
Mostly just to put your retirement back to where it was. That would be the only reason that I could see with it, that, oh, you took it out because you maybe expect to receive AFLAC later or something like that. And then you did receive the AFLAC. So now you have the income and you don't want to use your retirement after all. So you put the money back in. I honestly can't see too many people probably doing it, but maybe they come into extra money and then they can't, The added specific disaster distribution penalty tax exemption and repayment. This was added, like I said, with this Secure Act, so it will be included in the amendment. It lets you know that for these disaster distributions, you get that penalty tax exemption. Remember, with these penalty tax exemptions, you still have to pay the taxes on the distribution. You just don't have to pay the penalty tax for being under 59 and a half. It also allows you to repay this disaster distribution. So say you take that disaster distribution because your house burns down, then you receive the insurance money back. You want to repay it, put that back on the same page it was for your retirement there. The Secure Act also extended the AGI threshold for qualified medical exemptions or expenses for those penalty tax exemptions. For years, we kept going back and forth between 10% and 7.5% that we had to have those medical expenses over that amount. Now we have finally got a law change that says we're going to be 7.5% moving forward. Okay. So here's an overview of the steps that clients will take to pursue this type of retirement account. If you're looking to update those retirement accounts, each of these steps are going to be looked at in detail to where we make sure that we have a firm understanding of how this amendment process will go. The first step you're dealing with is the IRA plan agreement and disclosure statement. Both include rules and regulations that are required by the Internal Revenue Code or IRS. Either or both may need to be amended when new laws are enacted. Like I said, disclosure statements people typically update more frequently because when you have a new IRA owner come in that opens an account, you're required to have those up-to-date laws in that disclosure statement. Some people might have provide an additional kind of attachment saying, hey, these are the law changes that have occurred recently to that disclosure statement if they don't want to update their forms. But either way, these may either both of them or just one of them need to be changed there. Financial organizations are responsible for amending as required. So as we talked about, whose responsibility is it? Well, your forms provider that you use is going to actually update the forms. You're required to do the amendment process as a financial organization. You're required to make sure all your IRA owners, all of your beneficiaries have the updated information. You cannot just rely on your forms provider to change the forms and you do nothing on your side of things. There is a $50 fee per failure that may be assessed if the financial organization doesn't provide IRA amendments properly. Per failure, guys. So if you do not provide it and you have 1,000 customers that needed to be provided to, that already adds up to quite a bunch of money there, okay? So this is imperative that you make sure those IRA documents are amended and you get that out to all your beneficiaries and your IRA owners. So what is required then with these amendments? The plan agreement, we have two types of documents like we talked about. We have that model document, model IRS document, and the prototype document. The model document, we talked about, it's that 5305, those set documents with the set language. These are generally required to be amended when the IRS revises the model forms. That is typically the only time you're going to see that amendment. They have to revise the model forms. They tell us there's an amendment due, like what they did for December 31st, 2022. The prototype documents, however, they follow IRS guidance regarding amendments. The IRS will usually provide that listing of required modifications for them. When that's updated, they'll know they need to update that information for those amendments. Like I mentioned, those are not necessarily on the same timeline. They might get to do those more regularly in the model IRS documents there. Disclosure statement. Disclosure statements are required to be amended when amendments are made to that plan agreement, because the plan agreements affect the language in the disclosure statements. So someone tell me what a disclosure statement has in it. What is a disclosure statement? So we've got our plan agreement as our contract, but what is our disclosure statement? What information is that in that? Anyone remember? IRA rules in everyday language. Beautiful. Yes. IRA rules in everyday language, that non-technical language, it makes it easy to understand. So wouldn't it make sense that if our contract, our plan agreement changes, it's going to also change our disclosure statement too? That is true. Now, this disclosure statement must contain certain information about those IRA rules. It must make it easy to understand those IRA rules. When law changes have happened that affect the disclosure statements, we need to do an amendment. It's not required, but even if the plan agreement hasn't been amended, it's highly recommended. Why? Because when we have a new IRA owner that signs up, we are required to have an up-to-date disclosure statement at the time the IRA owner is opening that IRA. Therefore, we want to get those disclosure statements updated with those new law changes, even if a plan agreement hasn't been amended. Now, plan agreements we talked about, typically you're given that deadline by the IRS because it's a model document. They're saying, here it is, get it out to everybody. Disclosure statements, if no plan agreement is being amended, then there's typically no deadline on getting that up to date. It's just as soon as feasibly possible. And again, it's a recommendation, not a requirement, but it is a requirement to have it up to date for the new IRA owners. So see, it's kind of a little conflicting the way it's worded there. Typically, it pretty much is a requirement, in other words, okay? So you want to make sure you have those disclosure statements up to date as quickly as possible for those Treasury regulations.
So as you sign up new accounts or clients, those are all set because your amendments and everything will be all set. Previous clients, let's say from 2005, are they grandfathered in more or less in terms of the language?
I think I'm understanding the question there. So, I mean, they will, it is recommended to send it out to them as well at the time if you're updating that disclosure statement. But again, it's not that requirement. So it is the requirement to have the new customers have that information, but the old customers, you know, they're kind of just saying you don't officially have to update them until the IRS requires that amendment, I guess is a way to look at that. Does that make it a little clearer? It's kind of a confusing situation, so.
Yeah, just wrapping my head around, like, will a mass notice have to be sent to all clients, or is it just a moving forward once the edit has been made?
If it's an IRS required change, then a mass amendment has to be sent out to everyone. So the one in 2022, at the end of it, we have to send it out to old customers and new customers. If it's just we're updating the disclosure statement to stay on top of things, you want it to make sure your new customers have it mostly. It's a recommendation to send it out to your old customers, but not a requirement. So no one's going to look at you and say, well, why didn't you let your old customers know this information? Okay.
Thank you.
The plan agreement, that deadline for amending is going to be amend by the later 30 days after the amendment is adopted or 30 days after the amendment becomes effective. So for this new one at this point in time, December 1st is that effective date. So 30 days later is December 31st. That's why we say they have to be amended by December 31st, 2022. As we mentioned, this could change. We're waiting more guidance on this information. The disclosure statement we amend with the plan agreement. So you've got to get it sent out at the same timeline if that plan agreement's changing. If the plan agreement's not changing, you amend as soon as possible after there is a material change in information. And as we just said, amend, you have to give it to those new IRA owners, the old IRA owners. That is what is a strong recommendation, get it to, not a requirement there. So when are signatures required here? Well, amendments required by law changes do not require the IRA owner's approval or signature. There are specific lines in those model documents, Irs Form 5305, 5305A, and it says literally word for word, this agreement will be amended as necessary to comply with provisions of the Internal Revenue Code and the related regulations. Other amendments may be made with the consent of the persons whose signatures appear below. So something similar will also appear in Article 8 of the IRS Form 5305 and 5305RA. It will also probably appear in that prototype document. So what it is giving those financial organizations is the ability to amend and not have to go through getting a signature back from each of these people saying they want to keep it moving forward. Okay, so it's this non-signature event that you have rather than a signature event that could be a huge ordeal moving forward. Always, if you're concerned about whether or not a signature is required when amending documents, talk to your legal counsel or compliance department to find out what is required of you. And it is going to be different according to the plan agreements that you're on. They will say different information on it, like we talked about. It is recommended to include a cover letter with your amendment. What is a cover letter? Well, just like when we were filling out applications way back when for colleges and different things like that, and you had to send in your information to them or your resume, and you were sending information to them, you want to highlight the important parts. So in other words, what are the changes that are occurring in this document? Give a quick reason and why. Maybe due to Secure Act. These are the couple things to be looking for due to the Secure Act. We'll also tell you what that IRA owner needs to do. We do have a couple sample letters that we're going to go through here, sample cover letters that we're going to go through here. They are on page 11 and 12 of that PDF document you were given. 11 or 12 of the document we have here too. So if you want to look at that information as we go through it, you can follow along on that. You are required to send it to the last known address. So we send all amendments to that last known address of the individual who maintains an IRA. So we have to send it to everyone, right? What if that mail comes back undeliverable? Well, then you want to have proof that you sent it. So if that IRA owner comes in and says, I never received this information, you can say, well, we tried to give it to you, but you didn't update your information on file. Keep that undeliverable envelope in the IRA owner's file to prove the amendment was properly mailed. You're going to want to do that. Now, required documentation besides that possible envelope. In order to prove that you've done an amendment, there's two methods to do that. You can either, one, keep a master file. I like to think of it as like an Excel spreadsheet that has the name, address, everything like that of every individual that you mailed this amendment to. And then keep one copy of that amendment on file. Cover letter, whatever else you sent with that amendment on file. That tends to be the most conservative method because then you're not required to have a separate file for each person. You know, so that's the cheapest method, I guess, too, whenever you think about it. The other method would be to keep a copy of each amendment in each IRA owner's file. So that would mean every page of that amendment would be in each IRA owner's file moving forward. That way they know that they have it. The potential penalties, as we talked about, the failure to properly amend would result in that $50 per failure penalty there moving forward. So on to our cover letters. We include that cover letter with the amendment to explain the reason for the amendment, to give them information about why we're sending them all this paperwork. What is the point of it, in other words? Why do we do this? Honestly, typically speaking, a lot of people don't read plan agreements and disclosure statements and information like that. But they've received information from you, and so they're going, well, what is this? Well, they could read it and find out. But a lot of times they just call you and want you to tell them why. So this will stop a lot of calls from coming in if you have this cover letter that quickly addresses what's going to happen moving forward, that quickly says, this is what you're looking for. This is why these changes happened. The two sample letters that we have are on page 11 and 12. This first sample letter is on page 11, and that is going to be for those law changes actually. So the tax law changes in the IRS pronouncements. This goes into detail. It gives you an idea of what's easy to write. Notice it says you're part of this model document. Because of this pronouncement, we're making this change. This is an amendment to your blank, insert the plan agreement or disclosure statement. And then it also says in that next paragraph, you do not need to sign or return anything to have this amendment apply to you. You may want to consult your tax advisor to see if these affect you in any manner moving forward. And then it gives that number, letting them know if they have any additional questions. That other sample letter is going to be for amendments for pretty much any other reason on page 12. Now, if you want to have a signature event or you're required to have a signature event, then you might need to change the sample letter slightly to note that information, because this letter will say you do not need to sign. A lot of plan agreements will automatically tie. You don't need to sign for most things in it, so they don't have to get that extra step involved. But if yours doesn't, then there may be things that require that signature moving forward. So we've talked about our plan agreement, which is our P. We've talked about our disclosure statement, which is our D. Now our financial disclosure, our F. So our PDF, our P and our D have to be amended as required. Our financial disclosure never needs to be amended. No Treasury regulation requires financial disclosure amendments. So even if your rates, your investments change, we're never required to let those IRA owners know that information. Once provided, we never need to amend it. We never need to give this information out again, which isn't that great, because that is one of the worst forms and information to fill out until if possible, right? Our universal or catch-all amendment here. What is this now? Well, when an IRA owner administers IRAs, we're supposed to amend as required by law as things like this. Well, maybe you change personnel in the middle of something like that, and there's a person just learning about IRAs, and you actually completely miss an amendment. Oh, not just one, maybe you missed two. Well, do you want to have to go back and do this amendment and then do another amendment of the same document at the same time? That makes it really complex and hard to kind of follow as well, especially for the customers. You're probably going to be getting a lot of calls like, wait, you just updated this yesterday. Why am I getting it now? I know even when on Apple, they're like, hey, please agree to these new terms and conditions. I'm like, okay, accept. Like, I just ignore it. But you're like wondering, what did I just sign my life away to? You know, so that is the same kind of thing. They might call and ask a lot more if that's the case. So if we discover amendments were missed, one amendment, multiple amendments, we can't technically go back and make up past failures. So even if we were to send these out, it's not going to make it up. You've already failed. You've already made the mistake. But what you can do is you can send this amendment that has all of the new information in it, that amends for all the previous failures. It's called the Universal or Catch-all Amendment document. And it shows a good faith effort to keep these documents up to date. So it's not official that the IRS will say, oh, yep, you're in compliance, you're everything's good to go, but it's showing that good faith effort. So what you would do is send a complete and current plan agreement and disclosure statement to all IRA owners. Make sure it is most current, includes all of the changes there with that. This allows us to avoid gathering and sending many separate amendments like we talked about that were missed, and confusing those customers because amendment after amendment comes in. This catch-all amendment will include all relevant information about past rule changes for amendments which should have been made. Good thing to do would be including that in the cover letter, right? So like, hey, for this amendment, this, and this change, this amendment, this, and this change, we are now including it all in the final amendment, you know? There is no guarantee the IRS will not assess penalties for those past failures. You might still be subject to those past failures, even though you do this catch-all amendment. But it does show that you are putting in an effort, that you are putting in that good faith effort to bring the IRA into compliance, that you're trying to make everything better. If I were to ask, hey, we went through this change to be able to explain it, but as soon as I got on board, I made sure that everybody was up to date. We have this catch-all amendment to make sure we're good to go moving forward. Are there any questions on that type of amendment there that we're dealing with? So that's the basic of the law change amendments. What we have next here is the mergers and acquisitions. These are generally going to be assessed on a case-by-case basis. So it's going to depend on what's going on with the merger and the acquisition, what they've agreed to, who said they do what. But we are going to go through the basic guidelines for it. So typically this is what you're going to follow whenever you're dealing with those mergers and acquisitions. What happens if there's a change in ownership due to merger and acquisition or purchase? It usually affects the IRS documentation. That way, we have to update those IRA owners. You must review all the IRA related procedures and documentation to make sure you know exactly what needs to be updated and what you need to inform those IRA owners of moving forward. Newly created or purchasing organizations generally assume responsibility of the former organization. And again, this says generally, so this is not always the case. So they may not always assume that responsibility. They may have a different type of merger or acquisition where they do not assume that responsibility. So the first step is going to be to notify the IRA owners of that change in trustee, custodian, or issuer. We must let them know what has changed with this merger and acquisition. So in other words, new company name. What are we dealing with moving forward? Who will they be dealing with moving forward? Step 2 is going to be determine the amendments that are going to be needed with your legal counsel. So you're going to want to look at what amendments are going to be required to update the IRA for law changes and IRS pronouncements. Are there any amendments required for the new name, new trustee, custodian, issuer? What are we dealing with there? Are we required to amend to modify those IRAs to conform to the IRA program? Is there anything that we need to do to provide additional information for those IRA owners, beneficiary designations, IRA owners' birth dates? What are the requirements because they're coming to this new company? In other words, what does this new company that's merging with or acquiring the other company require that you didn't previously have to require? Okay, so it's pretty much like you're updating them at, yes, we didn't previously require that you fill out an application, but now we do. So we want you to fill out an application moving forward, things like that. The last step here that you're dealing with is you want to work with legal counsel to review the proposed amendment procedure. There are 2 different ways that you have these types of amendments. We can either do amend by negative consent or amend by that consent moving forward. Most mergers and acquisitions require an amendment of some type, and it's going to be determined by that financial organization's legal counsel. As I mentioned, those plan agreements can go into detail saying if this happens, you're required to have consent. Or if this happens, you're not required to have consent. The IRA owners agreeing to that as we move forward. So we have one step, which is positive consent. That means all IRA owners have to sign new plan documents to replace old plan documents. So we send out that amendment and they have to sign it and send it back. Negative consent is strictly sending the notice to those IRA owners of the proposed changes. And if the client doesn't object within a certain time period, typically they kind of give 30-day time period, but it may vary. Consent is deemed as being accepted. So there's, like, if you don't say no, you don't say nay, guess what? You're going with the yay. You're agreeing to those terms and conditions there. So that's negative consent. And like I said, negative consent would be outlined typically in that plan agreement stating that for these purposes, you get negative consent on it. Most plan agreements that you deal with. The last type of amendment that we'd be dealing with here is going to be an amendment required following a forms provider change. So what does this mean? Okay, some of you said you're on Wolters Kluwer. What if you decided to change to a census? You know, you're like, hey, a census is awesome, so I'm going to change to that. Well, I can already tell you, I know there are some difference between Wolters Kluwer's forms and a census forms. One of those being the default beneficiary. For those of you that were here yesterday with me, we talked about what's the default beneficiary in our document. If you're on a census forms, it's the estate. Do you know what it is if you're on Wolters Kluwer's? I do believe it's the spouse, and then it goes to the next in line from there. So same thing, you'd want to look at that default agreement on there. So just from that little example right there, you can see that if we change forms providers, things change. So what that IRA owner agreed to previously is no longer the case because we're on a new document. They would want to know that information, right? You have to provide them an amendment showing them that this is going to change. So what you need to do is review both current and proposed new forms to determine if an amendment is needed. Your legal counsel would be responsible for that. And they would be able to tell you, yeah, this is a significant enough change to where you'd want to let your IRA customers know, give them that information moving forward. You may also amend for law changes or IRS pronouncements at the same time as amending for new forms. So, hey, here in 2022, you know we have to have that new model document. You know we would be amending if you were going to change to a new forms provider. You could do it all in one, kind of have a catch-all between those two as well, where they see that information. We have reached the end of the amendment section. Are there any questions before we take a break here? All right. Well, how about we do a 15-minute break here? I'm going to put our timer up. And we will meet back here in 15 minutes. Always feel free to go ahead and chat any questions in, even if we're not actually in session at that point in time. I'll answer them as soon as we get back. My goodness, see if I can do this. All right. We'll see you back. All right, and welcome back, everyone. If you have made it back, go ahead and give me a thumbs up or something in the chat. Just let me know that you're good and ready to rock and roll here. Obviously, I can see you all. But if anybody else has made it back and is ready to go ahead and let me know. That way we make sure we have everybody. Howdy, I love it. All right, good. Looks like we have most people here. This next section is probably going to be a favorite for a lot of people. It is on those required minimum distributions. So what are we dealing with required minimum distributions? What exactly do they mean? We're going to talk about actually how to calculate an RMD. So what formula do we use? What information do we use in that formula? We're going to talk about the Rmd rules, when these apply, how they apply, and finally we're going to, explain the reporting requirements for that as well. Oddly, I never have my phone off of silent, and this is the one day I have in probably a year. So sorry about that, but we're going to talk about those Rmd reporting requirements and how they work. What are we required to do as a financial organization here moving forward? So RMDs, that's the familiar term most people use. What is an RMD? It's exactly what it sounds like, a required minimum distribution, a required amount that is needed to be taken from an IRA each year to satisfy the IRS requirements there. It applies specifically to traditional simple IRAs, SEP IRAs, if you're familiar with those, but it only applies to those types of accounts. It does not apply to a Roth IRA. Why is an RMD required? Well, the IRS developed these wonderful tax savings accounts, and suddenly they realized people were just keeping their money in there forever. Well, if they're in a tax savings account, the IRS is not receiving any money off of those accounts. Not because no one's doing any distributions, therefore they're not getting any revenue coming in from that. So RMDs are developed so we don't keep that money in that tax favored account forever. The IRS gets their portion of the funds as well. And we start to have to deplete that account because guess what? What is the middle word of an IRA? Not run, remember, it is retirement. So the IRS says you should be using this money in retirement. Therefore, when you reach a certain age, we're going to require you to take it out for retirement because you're retired now. So they set up a certain age that these are required to begin. It used to be 70 and a half prior to 2020. So if you turn 70 and a half prior to 2020, or another way of thinking of it is if you were born before July 1st, 1949, then 70 and a half was your RMD age. If you were born after or on July 1st, 1949, then your RMD age is going to be age 72. There is what's known as a required beginning date or RBD. Does anyone remember what day that is? What's the date for that RBD?
April 1st of the year following when you turn 72.
Perfect. Yes, that's exactly right. So April 1st of the year following your RMD age. So for some individuals, it was 70 and a half. For some individuals now moving forward, it's always going to be 72 for these people moving forward. Okay. So that is our required beginning date. What does required beginning date mean? It means while this is an RMD in your 72nd year, you are required to take in that RMD by this date. It better be satisfied. They give you a few extra months to satisfy your first RMD. Why? I don't know. Maybe it's to do with the fact that you're older and they want to make sure you remember that first time since it's something new. I don't know. There's no set reason on this. It's one of those things that they've just developed to give you that extra time. Now, if you wait till that RMD date, that required beginning date there, April 1st for that first RMD, we have to take 2 that year, remember? So we'd have to take 1 for 2000, if we're talking about 2022, and 1 for 2023 if we wait till April 1st of 2023 to take it. So just remember that if they wait, they might be subject to taking 2 RMDs at that point in time. Now, Roth IRA owners are never going to be subject to RMDs while the IRA owner is alive. So as long as the Roth IRA owner is living, no money is being required to be taken from that IRA. Another great benefit of those Roth IRAs there. So let's talk about one other item on this. There is a lot of non-compliance involving unconventional assets in those difficult to detect assets. They're difficult to confirm exactly the amount. So it's a lot of non-compliance happens with it. And it's hard to make sure those RMDs are done properly with the current IRA reporting system. Because of that, IRA owners that invest in those unconventional assets, such as real estate, those precious metals, those precious coins that are allowed, you might have private equity, they have a greater responsibility to actually understand and navigate those complex rules themselves. And that falls on them and to get that governed, that tax favored treatment of those IRAs. So they need to make sure that they are handling that properly and valuing that investment properly so RMDs can be calculated properly there and you lose that risk of that non-compliance. So it's just something to be aware of. If you're dealing with those hard to value assets, it does make RMDs a little more difficult to calculate moving forward. And you'll kind of see why whenever we move forward here with the actual formula that we're dealing with. So our RMD calculation, how do we figure out an RMD? Well, you use your IRA balance, and you may say, what IRA balance? Just any day. You actually use the fair market value, the December 31st fair market value of your IRA. So if we're calculating for a 2022 RMD, we would use December 31st of 2021 as our IRA balance. Then we divide it by our distribution period. And this distribution period is going to be found on the life expectancy table. We'll talk about those life expectancy tables here on the next few slides. Now you may be thinking, well, as an IRA owner, if you use that 1231 balance, there has to be a way around that, right? We've talked about transfers, we talked about rollovers. What if I make sure that no IRA actually has a 1231 balance? Then I don't have an RMD, right? Well, guess what, guys? The IRS thought ahead and realized that there might be cases where people might try and do that. So they have said that in addition to having that 1231 balance, you actually have to add back in a couple things. One of those things being outstanding rollovers and transfers. So say you take a distribution on 12/1/2021. Our 60-day rollover time period allows us to go all the way into 2022, right? So technically we don't have a balance in that IRA, in either IRA, as of 12/31. But we have to add back in that outstanding rollover that hasn't been rolled over into that amount of that 12/31 balance. So that is something that you do have to add back in order to count for it. You add it to the receiving, add to the receiving IRA any outstanding rollovers, which are distributions taken within the last 60 days of the year and rolled over after January 1st of the following year. You also have to add in any of those outstanding transfers that the same thing was done for. Remember, we add it to the receiving IRA's 12/31 balance. So IRA A is where we take the distribution from. It has a 0/12/31 balance. IRA B, we also had a 0/12/31 balance, but we rolled the money back in on January 22nd. We will add that to IRA B's 12/31 balance to come up with our IRA balance for Rmd calculation.
Would you use the last known amount before the rollover or the amount that actually got rolled back in?
I guess I'm confused by the question a little bit, sorry.
And maybe I have the rollovers confused, but say the client took a distribution in December, they're holding on to this money, and let's say they took $10,000, but when the rollover comes back in, they only rolled in 9,000 and decided to keep 1,000 as a distribution. Would it be based on the 10,000 pulled or the 9,000 put back in?
9,000 put back in, great question. Yeah, so it's whatever amount is put back into that account, that's what we would add to the zero balance or the whatever balance is still left in that IRA. Great question. So in this case, we had IRA A had that 12/31 balance, originally had $10,000. We do a distribution in December. It now has a zero balance, right? IRA B also had a zero balance. Of that $10,000, we choose to roll over only $9,000. We now have to add $9,000 into the IRA balance of IRA B. So because we add back in outstanding rollovers and transfers, we also have to think of other individuals that are allowed to roll over and transfer. And a spouse is one of these individuals. Sole spouse beneficiaries are allowed to roll over and transfer money into their own IRA. Anything like that into inherited IRA we're dealing with. So whenever they do it in the same year of death, there's no issue. Right? We know it's going into that account. We don't have to worry about it. So it's already in at 12/31. If the IRA owner died in 2021 and we do a distribution in the year after death, we take a distribution from an inherited IRA in the year after death and they roll it over later that year in 2022. So remember, IRA beneficiaries, or spouse beneficiaries can do it at any time. Then we actually need to add that amount back in to their 12/31 balance. So, I mean, this could be occurring as late as December 31st of 2022, and they would still be responsible for taking the RMD for that time period, including that amount. And that is their responsibility to know that information, unless we'll talk about different ways to inform them of their RMD amount, and there's ways to kind of know that you need to add that back into, okay? So we would add that back into that 12/31/2021 balance if they did it at any point in time in the year after the IRA owner's death. Now there's an additional thing to be noted down at the bottom there that says account balances used to determine RMDs will be reduced by the qualifying longevity annuity contracts premium costs, which will also reduce the taxpayer's RMD. This isn't something you're probably going to ever deal with, but if you do want more information on that, because you do deal with it, it's on page 2 and 3 of your job aids. So we talked about the IRA balance and how to calculate that IRA balance. Now we need to talk about that distribution period. How do we calculate it? What is it? Well, a distribution period is set to be the maximum number of years that you might live, that you might need to use this money from the IRA. Generally speaking, we're going to use that uniform lifetime table for those purposes. The uniform lifetime table is going to be the maximum amount you're required to take. Okay, as an IRA owner, if you use the uniform lifetime table, that will be the lowest life expectancy you're dealing with, which means you have to take out the most money. You're using that uniform lifetime table. we did get those new updated life expectancy tables here for 2022. So if you were using the lifetime table previous to this point in time, so you'd already turned 70 and a half or 72, and you'd been taking RMDs, your amount is actually going to get a little smaller than what it was in the past moving forward, because we get these new life expectancy tables. What these new life expectancy tables is, they actually increase the amount of time we're dealing with there. So we have to take out less money, okay? Previously, and you can look at your uniform lifetime table here, but in the information that you have in your book, previously this uniform lifetime table goes all the way to 115 plus. Once you got to age 115 plus, so you're older than 115, the amount was 1.9 forever. So you'd never technically deplete this amount. Now it goes to 120 plus. I don't know about you guys, but I'm sorry, I kind of don't want to live that long and find that out. So, but that's just something important to note there, is that this amount did increase. It is different than what it was previously. Looking at it, let's see here. If you look at 84 previously, it was 15.5, and now it's 16.8 listed on this chart. So notice there's, in some areas, there's almost a two-point increase. Other areas, there's not, but there is almost a 2-point increase in some areas. So like here, we've got 75, you've got the 24.6. Previously, it was lower than that amount. So moving forward, it will be different, and you will have to take out less money than this amount. So you would have used the previous table for 2021 and earlier, and that's going to be located in the job aid section if you're curious to look at that. Then moving forward, we're going to use this new uniform lifetime table, and it's found in that area I showed you about with the publication 590B or the IRS regulations, whichever one you want to choose. There is a time period where you may use the uniform lifetime table exception. What does this mean? Is it means if you are the sole spouse beneficiary of this IRA, that means you are the only beneficiary that's receiving money, or you've already established separate accounting, and that spouse is more than 10 years younger than the IRA owner, you can use that joint life expectancy table. So in other words, when I say more than 10 years younger, they have to be more than 10 years throughout that entire time period. So what this does is the IRS figured out that some people were marrying younger individuals. And whenever you think about retirement accounts, you generally think about it being for both you and your spouse moving forward, right? Well, suddenly these accounts were being depleted too quickly because people were marrying individuals way younger than them. And so that spouse didn't have the money to survive on come their retirement. So what they did is they created this uniform lifetime table to take into account both ages, where the individual would have to take out less money if they were married to someone significantly younger than them moving forward. So what it does is it results in a bigger number, which means less money needing to be taken out. I like to think of this joint life expectancy table that we're doing as being my Ryan Reynolds and Blake Lively couple table, because they are more than 10 years apart, okay? Ryan was born October of 1976. He's 46. Blake was born August 1987 and is 35. So what this allows for, they're more than 10 years younger than each other. She's more than 10 years younger than him. If Ryan were to have an IRA and to name Blake then he could use the joint life expectancy table. If Blake were to have an IRA named Ryan, he could not. So it is for the individual that has the younger beneficiary, not just either or. It has to be the younger beneficiary. So if you look at this, there's an example on the chart here that shows age 75. So say the IRA owner is 75 and the beneficiary is age 56. What you do is you take your fingers and you move down the two areas where the arrow's going and see where they intersect in the middle. They intersect at 31.5. So that's to show you that that would get you that life expectancy, 31.5 if you were to do the joint life expectancy. So remember, the IRA owner 75 here. If we go back to our uniform lifetime table, 75 was 24.6. So notice, by using this joint lifetime table, we get a big increase, and this number makes the number larger, which means less money taken out. This is something that you get a lot of questions on because people think, okay, well, I'm more than 10 years. There's more than 10 years between me and my spouse because it's 10 years and 1 month or something like that. It actually has to be 11 years technically. So what you do is you use each people's attained age for the year and calculate that, which means the oldest age each individual will be that year. So I like to use my husband and I as an example. I am actually a few months older than my husband. Yes, I'm a cougar in that sense. Not really, but I'm a few months older than my husband. Say it was 10 years and a few months older, we would still technically both have the attained age that year. So when you were to take our birth date of 1988 and subtract 2022 from it, we would both be 33 in the same year, right? So that's something important to realize that you're dealing with it, is that the attained ages would be the same there. So even though you might be more than a few months older than him, there's not a difference of 11 years. So if you look at this chart here, then if someone was born in June of 1948, so like we'll use my birthday is June, right? And we're doing 48 instead to make me old enough of 74. The amount on the uniform lifetime table would be, let's go back here. $74, we've got 25.5. So if I was born in June of 1948, I would have a 25.5 life expectancy using the uniform lifetime table. But if my husband was a sole spouse beneficiary and he was born in October of 1958, in 2022, he'd be 64. If you look at where these meet, 74 and 64 on the chart, notice that if it's 10 years, it's the exact same number as what it would be on the uniform lifetime table. So you have to have at least 11 years showing as being the amount between those two in order for it to be beneficial. So put him at 63 instead, and guess what? That number's bigger all of a sudden. Okay, does that make sense? All right, good. Now, if you have a sole spouse beneficiary, there are certain times when this may change throughout the time period in order to where it might change tables. So, you've got those two different tables. Typically, this is figured out. Distribution is based on the IRA owners beneficiaries on January 1st of the year. So what we like to say is that I have to be the sole spouse beneficiary for the entire year. Why? Because January 1st is when it's determined. There are a few times where this affects the table on which they will calculate things. Now, it may either affect it in the same year or it may affect it in the year after. So let's say we change from a younger spouse beneficiary to any other beneficiary. So previously, we were using that joint life expectancy table. If it's anything not due to death or divorce, and we were previously using the joint life expectancy table, and we are now going to the uniform lifetime table, we're going to change tables in the same year. So in other words, if I just decided, you know what, I don't want to name my husband anymore, I want to put my daughter down as the beneficiary. I do that mid-year, it wasn't due to death or divorce, I automatically have to go to that uniform lifetime table immediately there, if we were on the joint life expectancy table that year. Now, if it's due to death, the IRS says, hey, you didn't mean for that to change. Obviously, we give you this entire year here to go ahead and use that joint life expectancy table. But next year, you have to change to the uniform lifetime table because you no longer have that spouse that's more than 10 years younger than you as your beneficiary. If it's changed due to divorce and the beneficiary made that change in the same year, so I don't know about you, but if I go through a divorce, I don't want that person I'm divorcing, I'm assuming, to get the money, you know, previously that it was yours together, because hey, it's your money. You don't want the person that you're divorcing to get that money. So most people will make that change in the same year, because what if you do pass away? They want to make sure it goes to someone they want it to go to. So if that's the case, if you make that beneficiary change in the same year of the divorce, going from joint life expectancy table, you have to have the uniform lifetime table in that same year too. Now, if we wait till the next year, if you want to risk it and wait till the next year to make that change, you go to that uniform lifetime table the year after then. If the beneficiary changes to a younger spouse for any reason throughout the year, so you just now get married and you put them as your beneficiary, they were not listed as beneficiary as of January 1st. Therefore, you have to wait till the year after when they are listed as the sole spouse beneficiary for the entire year to go to that joint life expectancy table. Easy peasy, right, guys? This chart is one of those very useful charts to keep on hand. I think it's also in the job aids too, but I love this chart because it just makes it very simple and it lays out exactly all the things that might possibly happen that might result in a change of the table you're used to dealing with there. So now let's just talk about those general RMD rules. We touched briefly on this yesterday, but technically you could have multiple IRAs and each one could require an RMD. It is the responsibility of each financial organization to make sure that they calculate the RMD for that IRA. It's not their responsibility to know what your total RMD amount is. It's their responsibility only for the IRAs that are held by them to calculate that RMD for you personally there. So if you have multiple IRAs, multiple RMD amounts, that means technically that you could add those amounts together, aggregate the RMDs that have been calculated separately, and then take them from only one account if you wanted. Typically, you see financial organizations will request a notice from you if you're going to do that. When you fill out your RMD distribution form, I know our census forms has something noting, hey, I'm going to satisfy my RMD elsewhere. Just do this checkbox. A lot of financial organizations do that because that way, I know it's a customer service thing to kind of let those IRA owners know, hey, you have an RMD coming up. Do any of you provide an extra call or letter towards the end of year to remind those individuals who haven't taken those RMDs? Yes, okay. So I'm getting some yeses. You do too? Okay. So yeah, most people do. as a customer service thing. You would hate to continually every year remind a person who is taking their RMD elsewhere. So this helps us know, hey, they're satisfying all their RMDs from somewhere else. Do you as a financial organization actually know they took the correct amount? Can you see it yourself? No. But are RMDs a financial organization's responsibility to actually satisfy? No. They're the IRA owner's responsibility. They're responsible for making sure they take the full amount that is required of them between all of the IRAs total. Remember that this is going to be taxable in the year of distribution. What that means is that there's no backtracking and saying something can count for a previous year. If I take the distribution in 2022, it is taxable in 2022. It is taxable income in that year. It will be reported on the 1099-R, letting them know that information. If you're taking an RMD, you're over the age of 59 and a half. This means you're going to be reporting this as a code 7 on that 1099 for lucky number 7, right? Any RMD that is taken will be reported as a code 7. Some of you may be going, what about the things that aren't considered taxable? So for example, a qualified charitable distribution. For those of you that are unfamiliar with this, this is when an individual takes their RMD and they make the check directly payable to a charity of some sort. They can do that up to $100,000 and make that directly payable, and this would be non-taxable money. We still report that as a code 7, a normal distribution. It's not your responsibility to make sure that it's non-taxable. It's the IRA owner's responsibility to make sure that they're not taxed on this by filling out their 1040 properly. So that is a question you will get regularly because people think, well, this is showing I still owe taxes on it. Yeah, that's now your responsibility to make sure you report it properly to say it was a QCD. I'm not responsible for the taxes on that on the 1040 there. Remember, RMDs are always going to be the first money removed from your IRA. No matter what else you want to do, no matter what else you say, the RMD will always be the first money out of your IRA. So if you want to do a rollover later in that year and say, I'm going to take my RMD in December still, that rollover would contain part of your RMD, and for rollovers, you're not eligible to roll over RMD amounts. So when you put the money back in, you're going to be having an excess contribution and have to deal with that process. So one thing I like to recommend is always when you're dealing with someone who's after that RMD age, they're wanting to do something with their money, like a rollover, something different. Make sure they've satisfied that RMD first, even if it's not from your financial organization. Just ask them the question as a customer service kind of thing, saying, hey, have you satisfied your RMD for the year? Okay, then we can do a rollover then. You know, that kind of process. If you do not remove your RMD timely, you are assessed a 50% penalty tax on the amount you failed to remove. So if I had an RMD that was $200. I did satisfy $100 of that. I had $100 left to satisfy. 50% of $100 is $50. $50 penalty would be on that amount that I failed to remove. You would need to be, as an IRA owner, responsible with filing a 5329 to report this failure and pay the penalty. A lot of people will do that 5329 and add a letter with an explanation saying they have satisfied that amount moving forward and request kind of a waiver from the IRS saying, sorry, I didn't mean to. This was a boo-boo on my part. Please forgive me. I've made it up now. don't assess me the penalty. Most people that do that, I've never heard of someone actually being told, yeah, your excuse isn't good enough, but that doesn't mean things can't change. I know they're really trying to pick up on actually reviewing that information moving forward. So this is a 50% penalty for failure to remove for IRA owners, as well as beneficiaries that don't remove their amount that's required of them. So think about some of those beneficiary options that you're dealing with. You're dealing with those beneficiary options where they're required to take a certain amount by the end of 10 years. Well, what if they think they're going to take that entire amount the 10th year? So they leave $100,000 in their account the 10th year, and something happens. They don't take it, and we're in the 11th year now. 50% of that, $100,000, is a penalty. So it can be a large amount that people are dealing with. It's very imperative to make sure as an IRA owner and a beneficiary that you satisfy your RMDs. As a financial organization, we're not responsible for making sure they do it, but customer service, we normally provide extra help in making sure they do it. It's not a requirement. There's a couple things that are a requirement that we'll talk about, but actually physically them taking it is not our responsibility. So what about our Rmd Notice Reporting? What actually is this and what is required of us for this? If an RMD must be taken from an IRA and the IRA owner is alive at the beginning of the year, the financial organization that is the IRA administrator on December 31st of the prior year must provide a statement to the IRA owner by January 31st of the year for which the distribution is required. So in other words, if a distribution is required for 2022, the IRA owner is alive January 1st, 2022. The financial organization that has that account for the IRA owner would be responsible for letting that IRA owner know, hey, you have an RMD due. Okay, and this has to go out by January 31st. This is called our Rmd statement. A lot of people use the 5498 as their Rmd statement, and they kind of do this in conjunction with that fair market value statement. So they might do the 5498 where it provides all that information already for both the fair market value and the Rmd statement. Others will have two separate letters noting the information. Others will make their own letter going through all of that information in it. Now, you have two options when you're providing this Rmd notice. The first one being you can calculate it for them, calculate the Rmd amount for them automatically. If you calculate the amount for them automatically, you're always going to use the uniform lifetime table because that would be the largest number, right? So if they would have for some chance changed to the joint or change between the tables, the uniform lifetime table would more than satisfy the Rmd amount. Because remember with RMDs, we can always take more than the Rmd amount, but we can't take less or assess that penalty with it. So if we calculate it for them, we use that uniform lifetime table automatically. Also, we only use that 1231 balance. We won't have information to the outstanding rollovers or anything like that at that point in time. We also won't know what they're going to do 3 months from now either. So we always use that 1231 balance if we calculate it for them by January 31st there. You also must let them know that this statement is going to be provided to the IRS in that document as well that you're doing it. You can also, instead of calculating it for them, just offer to calculate it for them if they were to ask. And if they come in and ask for you to calculate it for them at that point in time, you're going to be responsible for using the correct table and taking into account all those outstanding rollovers and transfers added back into that 1231 balance. So you're responsible then for making it correct, using all of the correct information there. How many of you know which method you use at this point in time? You know which method you use?
We usually just send them the form and it has it right on there. I'm not sure how we get that, but
The actual amount then,
Mhm.
yeah.
Yeah.
Does everybody else normally calculate the amount as well? Yes, yes. Yeah, so a lot of people just go ahead and calculate them for it. And that's perfectly fine. Like I said, that's one of the methods that you can use. If this value changes, remember that's the Ira owner's responsibility to know that that's going to change their value and question it. Ask questions and make sure that they address it moving forward there. As I mentioned, it does require a note at the bottom stating that this is going to go to the IRS and that the IRS will receive this information. What that does is it pretty much gives them a heads up. Hey, the IRS knows you required this, right? You have no way to get out of it. It's not us just telling you, it's us telling you and the IRS this information. You have to satisfy it moving forward here. So as I mentioned, this is normally administered in conjunction with that fair market value because both are due on that January 31st deadline. If you use the Form 5498, there are certain boxes that will need to be filled out. So even if you're not using this as your Rmd statement, the first box will always be filled out, and that's box 11 here. Box 11 will always be filled out, noting that you have an Rmd for 2022 if an Rmd is going to be due for the individual. So we'll have to check that box moving forward for the 5498. Now, if you're using it for your fair market value, if you're using it for your fair market value and your Rmd statement, or just for your Rmd statement, fair market value, you'd have that box 5 filled out. And your Rmd statement, notice that it tells you box 12A and 12B. You have both the Rmd date and the Rmd amount. These are both required to be let know, or remember, if not the amount, you're letting them know you'll calculate. So even if you're not calculating it, you still need to let them know that the date that it's due by. So is it due by April 1st? Or is it due by the 12/31 balance time period? Okay, so you would fill this out if you're using this as your Rmd statement. Notice this is the 2021 5498, and we are talking about our 2022 Rmd. So you're always kind of a year behind. Technically on the form, it's letting you know what the upcoming year is going to happen with, what you have to do for the upcoming year, even though you're kind of getting that at the beginning of the year, a little way through the beginning of the year. It just lets you know those deadlines there and the amount there for that information. Are there any questions, anything like that, concerns on Rmd reporting requirements there? Okay, so next we have a calculating an Rmd exercise. This one is on page 26 to 27 of your guidebook. I want you all, I'm going to put a timer up, and I don't want anyone to say anything or type in any answers until after this timer is done. But what we're going to do is I'm going to give you 5 minutes, and you're going to go through all of these questions on your own. I want you to answer them. If you're in a group, feel free to talk about them amongst your group. But like I said, don't say anything over the line until we are back together here in 5 minutes. And I'm about to put up a timer here. 1 second. So 5 minutes starting now. And go ahead and work on those exercises there, and we'll get back together here in 5 minutes to discuss what our answers are going to be. And if anyone feels like they're going to need some more time to complete the exercise, try and chat into me and let me know. Another 5 minutes would be good. And remember, don't cheat. You all good? All right, now's your chance. If you need more time, chat into me. everybody's good to go, we'll go ahead and go through these questions here. So, okay, I get a request here to give a couple more minutes here. So we're going to give it a couple more minutes. All right, and to give people just a little bit more time before we go into that, I had a couple other things I wanted to hit upon with Rmd rules, just to remind you about. So we talked about you could aggregate IRAs, right? The IRA Rmd amounts. One thing that people think about is they think, oh, with inherited IRAs, I could always aggregate that amount from my regular IRA too. Inherited IRAs are completely separate from Ira Owners RMDs. Those RMDs have to be calculated completely separately, and they cannot be taken aggregately from one or the other. So if I'm an IRA owner and I also have an IRA I've inherited from my father, I have to take my RMD for my IRA myself, from my IRA that is for me, and then I have to take my RMD that's required, or also known as my life expectancy payment, that's required from my father's IRA, from that IRA. This also refers to separate, if you've received inherited IRAs from separate individuals. So maybe I have one from my mom and my dad. I can't, even though those are both inherited IRAs, I can't combine those RMD amounts and take them from the one account that I want to. I have to take one each from the separate ones. The other thing is people like to try and get out of the taxes, which is kind of the whole point, right? The taxes are what the IRS wants by setting up these RMDs. No, you cannot satisfy an RMD from a Roth IRA for your own IRA there. And you may think, well, I have two IRAs from my dad. One's a traditional and one's a Roth. I'll satisfy them all from the Roth so I don't have to pay the taxes, right? No, again, they got you there too. You can't do that either. The other thing to remember always is if you take amount out of your IRA, I told you it's the first dollars out for that RMD amount, the entire distribution, so the gross distribution amount, that box one on that 1099-R is what counts towards your RMD, even if part of it's a return of basis. So if part of it's non-deductible money and you're getting it back, it still counts towards your RMD. Even if all of it's a QCD, it counts towards your RMD. Even if you withhold money, so you don't physically receive that money, it still counts towards your RMD because that's the gross distribution amount.
What
One
about,
thing- Go ahead.
what about the fees taken by an organization on the account? Do those technically count towards an RMD, or are those exempt because it's a fee?
I think it would depend upon what kind of fee it is and when it gets taken out. Does it get taken out after the gross distribution amount, before? Most of them, I think, get taken out before you even note that gross distribution amount. So it's kind of something on the other side of it. Typically, the gross distribution amount is what is actually noted by the IRA owner, and it doesn't include that fee amount. Now, like I said, there are different kinds of fees, so we could be referring to something differently, where after distributing the check, you also have a penalty on something on that side of things. One thing I can tell you, even though it will show up in the gross distribution amount, is the removal of excess contribution. It will show up on the 1099-R in that box 1 gross distribution amount, but it will never count towards your RMD. So that is something that it's fixing a boo-boo. I like to think of it as it's kind of canceling out a previous thing. It does not count towards your RMD moving forward there. Clear as mud, right? All right, let's go through these. I can get my PowerPoint to come up there. Let's go through these examples we've got. So our IRA owner is Jack. The date of birth is June 21st, 1949. Our primary beneficiaries are Rebecca, born March 14th, 1949, who is a spouse. Kevin, born February 19th, 1971, who is a non-spouse. Kate and Randall, born that same date, who are also non-spouse beneficiaries. Does anyone know where these names came from? Anyone else watch it? I know I do. So Sad is coming to an end. This Is Us, in case you don't know, is the name of the show that these names came from. Yep, exactly. My husband calls it the crying show because every time I watch it, I seem to cry with it. Yeah. Anyways, so December 31st, 2021, our balance is $56,257.83. What is Jack's attained age in 2022? Very good. Everyone keep chatting those in. Remember, I like to see your answers. Very good. Everybody is spot on there. 73. How do we figure this out? Take 2022 and subtract 1949. That's the age he's going to be that year. That's the oldest he will be in that year. Do you need the attained ages of his beneficiaries? Why or why not? If so, what are they?
I said no, because there's more than one beneficiary.
Very good. Everybody that's chatting in no, tell me why or why not also. Very good. You guys are right. So no, Jack does not qualify for the Uniform Lifetime Table exception, also known as the Joint Life Expectancy Table. Why? Because there are multiple beneficiaries listed. Rebecca is not the sole spouse beneficiary. She is also not more than 10 years younger than Jack there. So because of this, which table will be used to determine his distribution period? Very good. Uniform Lifetime Table. You guys are spot on. What is Jack's distribution period? Good job. Very good, everyone. 26.5. Now we got the math thing, you know. Let's calculate that RMD for 2022. What is it?
21, 22, 94.
Very good. All right, everybody, you guys are spot on. So it is 21, 22, 94. How do we figure this out? We take that fair market value amount of $56,257.83, and we divide it by his distribution period of 26.5. That's when we get $2,122.94. Now we're going to talk about Tom. And Tom is the Ira owner. He was born July 4th, 1943. He has a primary beneficiary who was born May 12th, 1961. Her name is Alexandra. She is the spouse and was the spouse listed as that primary beneficiary for that entire year. The contingent beneficiaries are Leo, who was born March 23rd, 1983. Leo is a non-spouse beneficiary. Penny was also the contingent beneficiary listed. She was born December 17th, 1991, and a non-spouse beneficiary as well. The December 31st value for 2021 is $88,366.71. What is Tom's attained age in 2022? Very good. 79. You guys are spot on there. Tom's attained age in 2022 is 79. How do we figure that out? We take his birth date from 2022. So 1943 from 2022 there. All right. Remember, everyone, chances are, it's not like when we were younger, when we were always told by our teachers, I mean, come on, you can't use a calculator. You're never going to have one in your back pocket all the time. We all have calculators in our pocket now, guys, our phones. We are there. So I love saying, teacher, you were wrong. Math was never my favorite subject, so calculators are my best friend. Do you need the attained ages of his beneficiaries? Why or why not? If so, what are they? Good. Yes, Tom qualifies for the joint life expectancy table because his spouse is more than 10 years younger than him and is his sole beneficiary. Alexandra's attained age is 61. She's more than 10 years younger. So what table will he use to determine his distribution period? Good. Good job, guys. Joint life expectancy table. You guys are spot on there. What is Tom's distribution period? $27.0. On that unit or the joint life expectancy table, 27.0 is his distribution period. Remember, we find where those 2 points intersect, and that is what our distribution period is going to be. Let's see here. What is his RMD for 2022? So let's dig out those calculators and calculate that RMD amount. Good. So we take the 12/31 balance of $88,366.71, divide it by 27, and we get $3,272.84. So last question here before we take our lunch break. And that question is going to be in regards to talking about beneficiaries slightly here, just to make sure everybody's still remembering that process. And if you weren't here yesterday, refreshing your memory on that process. So who is going to receive the money if all of the beneficiaries are still alive at the time of Tom's death? So with our beneficiaries listed here.
Primary,
Yep. And who is that in this case?
Alexandra.
Perfect. So Alexander Rowe will receive 100% of the money. Now, if Alexandra passes away prior to Tom, who will receive the money?
Leo and Penny.
Very good. So remember, primary beneficiaries, if they're alive at the time of the IRA owner's death, it always goes to them. Contingent beneficiaries only get the money if all primaries are gone. So in our previous example here, we had Rebecca, Kevin, Kate, and Randall, right? They're all listed as primary beneficiaries. So let's talk through this one. So if Jack dies, it splits 4 ways, right? We'll just say it's equally done in this case. But let's say, because Jack and Rebecca are both around the same age here, very close in age, Rebecca's gone before Jack. Where does Rebecca's share go? Very good. Split between the other 3. You guys are exactly right. So Rebecca's estate won't receive a share because she predeceased Jack. Now, if she were alive for Jack, like in This Is Us, then they would receive, and then she passed away at some point in time later and hadn't done distribution, then you're dealing with that information from there. But if she predeceases the IRA owner, she doesn't get that share. Okay. If all of these primary beneficiaries were to pass away prior to the IRA owner, where would the money go?
Probate.
You skipped one step though, but yes, pretty much that's the answer.
First found blood heir.
But you need to look at what? Depends on your form. Someone said it. Your plan agreement. So that default on the plan agreement. So some of them might have someone else listed on there as an option. I'll tell you, a census has the estate, which means it goes to probate pretty much there. That's what you're dealing with there. Okay, so good answers. All right, you guys are spot on. Does everybody want to do an hour lunch again today here? Yep, you good with hour? Okay, perfect. So I'm going to set our timer here now that we've got this wonderful thing working for 1 hour. And so that puts us getting back here right about 12:45, a little after. All right, enjoy your lunch, everyone. All right, everyone, and welcome back. I hope you all had a great break and you were able to kind of refresh yourself and get going. If you're like me, I know that you might be a little more tired than we'd like to be. You're kind of hitting that lull in the day. You're ready for a nap. You know, I love taking a nap. My coworkers always used to make fun of me when we were still in the office because during my lunch break, if they couldn't find me, I would always be under my desk napping. So yeah, that's me. Anyways, we will go ahead and hit the ground running. But before we do, I have a joke for you all. In light of the fact that we have the new W4R, I'm going to ask you, we have a nap couch in our break room. Oh, that's awesome. I wish. Yeah, I love that. But in light of the new W4R, I've got a question for you. What is a pirate's favorite letter?
R.
Well, you'd think it'd be the R, but it's actually the C. Yes, I know, super corny, but good. I love it. So, anyone else have any jokes they want to share to wake everyone up before we get going on the beneficiary options? Because this is a heavy, heavy topic we have here ahead of us. All right. I'm not hearing anybody pipe in, so we are going to go ahead and get going on this part here of beneficiary options. Feel free to share jokes at any point in time, especially if they're super cheesy. My favorite. So our learning objectives for this section, after completing it, you will be able to talk about and understand those beneficiary distribution options for when an IRA owner dies on or after January 1st, 2020, as well as the time period before too. So we will talk briefly about that as well. We're also going to talk about the differences for the different types of beneficiaries. What are the names? What do they mean? How do they apply to what types of options we're going to have available to those beneficiaries? So we do have a heavy topic, like I mentioned, ahead of us because there's a lot of information. First, moving forward, whenever we have a death for an IRA owner, what is the first step in any process that you should do whenever you're dealing with a death that somebody wants to claim their assets they're following? So if IRA owner dies, what should we do before we do anything else? Death certificate, exactly right. So get that certified death certificate. Make sure you have the proper information. We don't want to be like one of those individuals I forewarned you about yesterday, where they distributed to those beneficiaries without having the proper information. And guess what? Later came out that IRA owner came back looking for where that money was because the IRA owner was still alive. So make sure we obtain that death certificate before moving forward. We must always follow those procedures. So anything you have in place for that, follow the procedures that are necessary when making those distributions to those beneficiary. Obviously, those procedures are going to depend on when the IRA owner died and the option chosen. So there's different things that you have to do depending upon when the IRA owner died, as in what year, as well as the age that they died at. What I like to think about when you're dealing with IRAs is there are several questions that you have to ask whenever you've got a beneficiary. First one is going to be, how old was that IRA owner when they passed away? In other words, were they of RMD status? The second one is going to be, what year did they pass away in? What that one's triggering is, are we going to know, are they before or after January 1st, 2020? And then you want to know the type of the beneficiary moving forward too. Is it a spouse? Is it a child? Is it a minor child? Is it an adult child? Is it a sister? What are we dealing with there? So those are the things that you're going to want to know, and make sure you keep a reminder of, ask those questions where you can properly figure out what those beneficiary options are for that individual moving forward. So the first section here we're going to talk about is the death on or after January 1st, 2020. With the Secure Act, we had several changes made to these beneficiary options. The first one is going to be explaining a new terminology that we have with IRAs, and this is called an eligible designated beneficiary. So what is an eligible designated beneficiary? Well, it falls into one of these 5 categories here for the individual. So you've got a spouse, that's always going to be an eligible designated beneficiary. That one's pretty self-explanatory, right? An IRA owner's minor child. According to the IRS, we are using the age of majority as of 18. Moving forward, they have verbally agreed that 18 is that minor child limit, even though different states may have different ages of majority for this. So if the individual is under the age of 18, they're considered that minor child. Therefore, think of it this way. At one point in time, someone could be an eligible designated beneficiary, and their brother or sister could not be as well. So I have a coworker, he has 2 daughters currently, and one of his daughters is still in high school. She's only 16. The other one is in her 2nd year in college. So what do you say, 19, something, 20, something like that. So if he were to pass away right now, his children would have 2 different options. One would be an eligible designated beneficiary, the youngest one, and would get that minor child benefit. The oldest one would not be. So that's one of the things you have to remember with children there. A disabled individual is always going to be that eligible designated beneficiary. You would want to, like with all things when you're dealing with that disabled or chronically ill, request for some kind of proof if you're going to move forward that way. Is it a requirement? I would say it's highly recommended because you're reporting it differently or you're allowing them to do something. So you kind of want to have the information why you allowed them to do that. But in the long run, it's between them and the IRS to prove why they should have been allowed to do that too, if they were to ever question. So chronically ill is the next one. Being not more than 10 years younger, I always like to explain in a little bit more detail because to me, this is such a weird wording, right? Not more than 10 years younger. Okay, so let's dissect what that means. If I'm not more than 10 years younger, then that means I am older than the IRA owner. That's one option. It could also mean I'm only 9 years younger than the IRA owner, between 1 and 9 years younger than the IRA owner. But if I'm 11 years younger than that IRA owner, that means I'm not an EDB. So let's dissect why these are considered eligible designated beneficiaries. So the purpose of these new payout options that we have received for beneficiaries is because the IRS wants to get the money out quicker, right? So for most of our beneficiaries want to get the money out quicker. So they designated only certain individuals that would fall into this category to get to do life expectancy payments over their life expectancy. So let's talk about the first thing. Who do most people name as their beneficiary? First beneficiary.
Spouse, primary, and children contingent usually.
Correct. So I don't know about you guys, but I hope my spouse doesn't die before me because I don't think I can handle it, but that's just my opinion. So other people might want it the other way. I don't know. I not dissecting that, but you typically see that order. You have the spouse. If the spouse predeceases you, then it goes automatically to the children. Or, once the spouse has predeceased you, you change it to the children. However, whatever fashion that is. Most of us hope that by the time we pass away, our children are of age of majority at that point in time. We all hope we reach that older age our children are long past the age of majority, so they're adult children. What does that mean? What category would they fall into? Well, they wouldn't be considered an eligible designated beneficiary anymore. So the majority of the time here, we're going to be leaving this money to people who are not eligible designated beneficiaries, which means they have to have that more rapid payment we're going to talk about. They need to get the money out quicker. They're not going to get the benefit of having that life expectancy payment that eligible designated beneficiaries get. So it is important to note that a good majority of the people are losing a benefit that they would have previously had by this, because they fall into that category of not more than 10 years younger. Most of our kids are definitely going to be more than 10 years younger than us. I'm not sure there's anyone out there that way, but I wouldn't second guess anything. So eligible designated beneficiaries. We talked about the first two questions being when the IRA owner died and at what age they died, to figure that out. The next one is to determine the type of beneficiary. We first need to determine if they fall into one of these categories of an eligible designated beneficiary, or if they just be a designated beneficiary because they are not one of these individuals listed here. So I like to give the example of an eligible designated beneficiary in a lot of different ways here to make sure everybody is on board. So for those of you that remember yesterday, and those of you that weren't here, I'm going to kind of review it. My husband's name is Wes. Wes would be considered a spouse beneficiary. Therefore, he is an eligible designated beneficiary automatically because he is a spouse. My mom and dad, Bill and Kathy, they would also be eligible designated beneficiaries. Why? Does anyone want to tell me what category they would fall into on those eligible designated beneficiaries? So which one of these would they be? They would fall into this, this last category here, not more than 10 years younger, because they are older than me. They're considered eligible designated beneficiaries. So why would the IRS let them do life expectancy payments over their life expectancy? Well, since they're older than me, their life expectancy is going to be less than mine was. Therefore, the IRS isn't losing any time. They're actually gaining some time before those payments would come out. They're going to come out more rapidly even than what they would have with me. So see how that works when they're older? That life expectancy isn't being out more rapidly. You're dealing with it more rapidly. We have my daughter, who is 2.5, daughter Blakely. She's 2.5 right now. My son on the way. If they were named beneficiaries, they would both be considered eligible designated beneficiaries because they are those minor children. My niece, though, my niece is only 11 years old. Would she be considered an eligible designated beneficiary?
No,
Correct.
because you're 33.
She would, well, say I passed away then and we're dealing with it later on, she would not be considered an eligible designated beneficiary because even though she's a minor, it's not the IRA owner's child. Okay, so she's 11 years old, so she is a minor child, but this one is specific. It's the IRA owner's minor child, so she'd have to be my minor child in order for it to count. She's my brother's, so that doesn't count. Someone said only if you adopted her. Touche, exactly. So that would be the only way that you would deal with that. Now, a charity is obviously not going to fall into any of those categories, is it? It is a non-person, so it's going to be its own separate category there that you're dealing with. So when we look at this chart, I want you to think of this first chart, and there is a lot of charts through this beneficiary options section. So I'm going to try and tell you what each one is good for, and then that way you can keep that in mind when you're moving forward. This chart specifically dictates who gets what option and how it affects them depending upon their relationship. Okay, so they might get a different option because of their relationship, and this chart is specific to that. So let's look at those options to an eligible designated beneficiary. Notice there's two categories under eligible designated beneficiary. You have your spouse beneficiary. Spouses always get the best options. They always get more options by being a spouse beneficiary. Why? The IRS kind of considers that your and your spouse's money. So they say, you're leaving it to your spouse, they should get the benefit of doing whatever they want with the money at the same time there, okay? A non-spouse beneficiary are going to be any one of the other eligible designated beneficiaries we talked about, that minor child until age of majority, all of those individuals following that point in time. So the first three options for all eligible designated beneficiaries are lump sum, 10-year rule, and life expectancy payments. And we'll go into detail about what these actually mean moving forward. But those are allowed for any eligible designated beneficiary, no matter if it's spouse or non-spouse. A spouse beneficiary gets an additional 2 items of having transfer to own IRA or distribute and roll over to own IRA or eligible plan. Remember that this is very specific for those non-spouse beneficiaries. It says minor child. So obviously, children are going to continue to get older as we go through. So even though they had life expectancy payments when you first passed away, once they reach age of majority, they're required to switch over to the 10-year payout starting at that point forward. And like I said, we'll talk a little more in detail about that here in a few slides. But just so you know, that is the rule there. So you could be an EDB at first and then switch over to a not eligible designated beneficiary later on. Now, if we are not considered an eligible designated beneficiary, this category I want you to think of as literally every other person other than the ones who are eligible designated beneficiaries. So any living human being, they would fall into this category if they are not already in there, the EDB category. What do they lose? They lose the life expectancy option if they're not an EDB. That's completely taken out of their choices. They only have the lump sum and 10-year rule. Non-beneficiaries, their options actually did not change. They now, if it's a Roth IRA owner, we know they never have RMDs, so it's always considered before RBD because they're never required to take any. But if it's a Roth IRA owner or traditional IRA owner before RBD that died, they get the same options of lump sum and the 5-year rule. They had this previously as well. If it's a traditional IRA owner who died on or after required beginning date, they get lump sum and life expectancy option. These are the only options available to them, okay? Life expectancy payments, then when you're dealing with it after RBD as a non-person beneficiary, it's then going to be based on the IRA owner's life expectancy. That's why it's not increasing or anything like that, because obviously an estate, an account like that will not have that to where you can use their own life expectancy of that individual there moving forward. So let's talk about what each option actually means. So I'm going to give you a few tips to remember things. Lump sum is what I like to think of as the take it and run option, right? As a beneficiary, it's available to everyone. Non-person, non-spouse, EDB, non-EDB, charity, before or after required beginning date, I don't care when it is. A lump sum is always available if you're a beneficiary. You could even choose one of the options and then take a lump sum. A lump sum is always available to all beneficiaries. So when I ask that, remember, it's any time, no one doing it. There's always this available, okay? I did get one question that I didn't see a minute ago. Non-person beneficiary, what happens to Roth after RBD? There is no after required beginning date with a Roth. It's always before required beginning date when you think about that, because there's no required beginning date for Roth. There's no RMD. So we are never required to take distributions. So we always deal with it on the pre-RBD side of things. Question. All right, our 5-year rule here, this explains our 5-year rule and what it actually means. Whenever you have a 5-year rule, it is an option available to only non-person beneficiaries if we're dealing it after January 1st, 2020. This is only an option available to those non-person beneficiaries, and it's only going to occur if they were prior to the required beginning date, or it's a Roth IRA owner who passed away. And they name a what type of beneficiary? Non-person beneficiary. So think 5-year rule, it has to be a non-person beneficiary, and it has to be after required beginning date. Before required beginning date, or a Roth IRA in order to be able to use this option. The 5-year rule means exactly what it sounds like. They have 5 years from the time, the 5th anniversary of the IRA owner's death, to take that distribution, to take all the money out of the IRA. So it has to be depleted by the December 31st of the year we share. Oh, sorry, I think somebody is sharing something. 1 second here, guys.
Whoever Josh is sharing his screen and we can see email.
Okay, everybody should see the black screen here. Everybody see my screen again?
Yep.
Okay, great. All right, so we must deplete this account by the end of the 5th year. What does this mean? This means that I can take $0 the first year, the year of death. I can take $0 the second year, 0 the third, the fourth. By the end of the 5th year, I must take the entire balance. If I don't, we're dealing with that excess accumulation penalty again. So here is an example where it shows the death of the IRA owner occurs in 2022. We have 5 full years when you look at it this way. So all of 2023, all of 2024, all of 2025, all of 2026, and all of 2027 to deplete this IRA. Question that happens frequently: can they set up payments to go regularly each year? They can. There's nothing against this. It's just not a requirement. Now, another thing that gets asked frequently is, well, what if they don't take it all then by the end of that 5th year? Like I said, you have that 50% excess accumulation on the amount that should have been taken, which is the entire balance. So if they didn't take $50,000 of it, excess accumulation on that full $50,000, or yeah, on the $50,000, which would be $25,000 that they would owe. Okay, so this does have to be satisfied by the end of that 5-year period. There's no set amount each year. It could vary, or they could have a set amount each year depending upon what they wanted.
So it's 5 years and to the end of that calendar date, or 5 years up to the birthday or the death day of the individual?
Great question. It is December 31st of the 5th anniversary. So technically a full 5 years, let's say the IRA owner passed away January 1st of 2022. they're technically almost getting 6 years, aren't they? Because we go all the way to the end of 2027 with it. So think of it as we go to that 5th year anniversary, then we have to go to the end of the year from there. That makes sense? Okay. So that's the 5-year anniversary, that's the 5-year rule. And remember, who is it available to? Who is the 5-year rule available to? Non-person beneficiary. Good. Non-person beneficiaries, the 5-year rule is only available to non-person beneficiaries, and the IRA owner has to die before required beginning date, or it's a Roth IRA. Good.
I found this on the web.
I watched. Awesome. I'm glad you found that on the web. Watch. All right. Our 10-year rule. We've got pretty much the same situation, except we expand that rule to 10 years instead of 5. Difference being who is eligible to use this option. So with the 10-year rule, you're going to be dealing with all of those people who are not eligible designated beneficiaries. So the individuals who don't fall in the EDV category, they get this option for or after RBD anytime. Eligible designated beneficiaries, they're going to get this option too. There is a little bit of controversy on this, and I like to bring it up because according to the actual Secure Act rules, according to the regulations the IRS put out, the 10-year rule is available to all ABBs, period. According to publication 590B that just recently came out in the draft and came out last year with this information also, it says in there that an EDB can't do this if it's after their required beginning date. So if the IRA owner has already had their required beginning date, they can't do the 10-year rule if they're an EDB. They have to go with the life expectancy payment. At this point in time, you go based upon the higher power of which rules have the higher power of, I guess, being secure, being known that it is the truthful amount. And the most truthful, the higher power there is going to be the actual Secure Act rules. And at this point in time, they still state that you can do the 10-year rule as an EDB or just a designated beneficiary at any point in time. So I base it off of that. So think of the 10-year rule as any person beneficiary. Any person beneficiary can do the 10-year rule if the IRA owner passed away after January 1st, 2020. This is the same thing as the 5-year rule. They have 10 years to deplete the IRA. And it's not 10 years from the death, it's 10 years from, and then December 31st of that anniversary. So if they die in 2022, it'll be 12/31/2032 as having that 10-year rule. They need to have everything depleted from that IRA at that point in time. Okay, so we've got the 5-year rule only available to non-person beneficiaries before RBD or Roth IRA. We've got the 10-year rule, the 10-year rule available to all non-person beneficiaries. Hey guys, I'm saying these things a lot of times. That must mean it's important. So make sure you remember this stuff here. And then we got transfer or distribute and roll over. Only available to spouse beneficiaries. This is an only available option to spouse beneficiaries. This is available to them. Both of these options are available to them, no matter how old the IRA owner was when they died, and at any point in time. They never lose this option here. If it's a sole spouse beneficiary transfer, that's the only time they get to use this, or if separate accounting has been established. So what do I mean by separate accounting here? We're going to go into more detail about that in a few slides, but just realize that in order to transfer the money, also familiarly known as treat as own, a spouse beneficiary has to be the sole spouse beneficiary in order to do that, or they have to establish separate accounting from all of that. We can transfer this money from like to like account, traditional to traditional, Roth to Roth, of that spouse beneficiary's money. And it would move via transfer, even if it's coming out of, for example, my IRA and going into my husband's IRA upon my passing. It would still be coded as a transfer if it's moved directly. It would be recorded as a rollover if he takes the money out as a distribution, gets it in his hands, and then puts it into the other account from there. Again, it's going same IRA type. So a spouse beneficiary can do this. The difference between that transfer and rollover is that we're dealing with a rollover. It is going to be reportable. So we'd report it going out and in, that distribution going out and into the new account there. This is always an option, like I said, for any spouse beneficiary. This is always an option. Now let's talk about those life expectancy payments. But before we do, I want to mention one other thing. Remember, I did say if separate accounting is established, you can do that transfer. If it's not established, we don't lose the rollover option now. So if it's not done timely, we still could always distribute and roll it over to our own IRA as a spouse beneficiary, which has always been kind of a funny thing to me. It's like, well, if you can get it over there no matter what, why not just allow for both? But they say that you can only do the transfer if you're the only beneficiary there. So that's the one other thing you might want to remember on that. Life expectancy payments. Hey, this formula looks pretty familiar, right? Remember it from our required minimum distributions. We have that account balance. That is going to be the 1231 balance. And it's going to be divided by the distribution period. This is going to be a different table used, but it will equal your life expectancy payment. In order to keep these separate, I like to think of them as totally different types of accounts. So you have your IRA owner. An IRA owner is required to take required minimum distributions. An IRA owner can contribute to his IRA. An IRA owner can take a distribution and roll the money over. A beneficiary cannot do those things. They cannot contribute to that IRA. They cannot do anything like that. So while it is an inherited IRA, it's not treated like an IRA. It's more treated like a savings account that has that tax shelter benefit that you are required to take distributions from. That's why they have that difference in terminology too. These are life expectancy payments. These life expectancy payments are only going to be available to eligible designated beneficiaries. Non-person is not going to get that benefit. Now, a life expectancy payment can go, non-eligible designated beneficiary is not going to get that benefit. A non-person could do a life expectancy payment if it's after RBD, but it's for the IRA owner's life expectancy. So they're not going to use their own life expectancy. We would use a single life expectancy chart anytime we're dealing with life expectancy payments. So think of when the IRA owner is deceased, we no longer have to think about joint life versus uniform life. It's always single life expectancy table if the IRA owner is deceased and it's coming out of an inherited IRA. Always single life expectancy table. These beneficiaries are required to take this amount just like RMDs. If they do not satisfy it, it is also going to be subject to that 50% penalty tax in regards to it. There are two methods of doing this life expectancy and calculating the life expectancy. Recalculation method is used for the spouse only. What this means is that we look at that life expectancy table in the year after death. The first year they'd be required to take those distributions. So it may not always be the year after death. The first year they're required to take their distributions. And then every following year, we check the chart again. So we always look at that spouse's age again. Non-recalculation, that's going to be used for the non-spouse eligible designated beneficiaries, and then certain non-person beneficiaries. And I'll explain the difference in how those two are going to be calculated there. But non-recalculation, what it does is we look at the first year that they would be required to take those life expectancy payments, generally speaking, the year after death, for those non-person eligible designated beneficiaries. We look at that year after death, look at their age on that chart, the oldest age they'd be, and then every year we subtract 1 from that life expectancy we found on the chart. So if next to age 15, we found 39.2, I'm just throwing weird numbers out right now, but we found 39.2 next to 15, the next year it would be 38.2. We subtract 1 to move forward. Now, if we're doing that non-person beneficiary, we do have to look in the chart in the year of death because we're using the IRA owner's age. And that IRA owner will never get older than that year. That is the last year they're considered of that age. So we look at the oldest that IRA owner would have been in that year on the single life expectancy chart. And then for our first year, we actually have to subtract 1 before even moving forward for that first year. So first year is going to be the year after death. I'm going to go over some examples here to help clear that up. So if we're dealing with a spouse beneficiary, you're going to have a recalculated option for year 1, looking at 20.4, 19.6, 18.8. Because in the year of after death here, the first year they're required to take distributions, they're 68. Every year following, we look at this number on the chart. 69 the next year, 19.6. 70 the year after that, 18.8. So we always look back at this chart. If it's non-recalculated, year 1 was 68, remember? 20.4 here. Every year following, we subtract 1 from this number, so you get 19.4 and 18.4. Notice it's not a huge difference, but as time passes, it will become a much bigger difference the more and more years that go by there. So the recalculation method allows for them to have a little extra time because they're that spouse beneficiary. Now they could always treat it as their own, and then they're using that uniform lifetime table and they get even more of a benefit, even more of a time period with it. But if they keep it in that inherited IRA, this is the method they would be using moving forward. Does that make sense? Any questions on that before we get into the transition rule, which kind of makes it even more complicated? All right. So our transition rule, we updated the single life expectancy tables. We updated all of our tables here in 2022. What this allows for is it allows for those beneficiaries where the IRA owner, the death of that IRA owner was in 2020 or earlier. So why is it just for those? Well, let's think. If the IRA owner were to pass away in 2021, the first year we'd be doing a distribution would be 2022. So we'd automatically use the new charts. We'd use those 2022 charts. It's only if they passed away in 2020 or earlier where we were going to have used the old life expectancy charts. So this would apply to those deaths before January 1st, 2021, or in other words, deaths that occurred in 2020 or earlier. It allows them to do a one-time reset where we look at this new chart instead of the old chart. Why? What is the benefit? It decreases the RMD amount that is required of them. It decreases that life expectancy payment. Longer life expectancies are what we are getting out of these new charts, which means the numbers on that chart get larger, which means the amount the IRA owner or beneficiary is required to take gets smaller. In order to do this one-time reset, we do have to use the age that would have been at the start of these payments and then subtract 1 to get to the number you're supposed to be at. To me, when I first heard that, that was really confusing until I actually saw an example. So we're going to do an example. Remember that this is going to be moving forward in the future. They'll always use this new single life expectancy table, but they're allowed to do this one-time reset to get to the new table as well for those beneficiaries. A question we get asked regularly is this required? In short, no. Think about it this way. If they use the old tables, their life expectancy is smaller. Therefore, they're taking out more money than what is required of them. Because their now requirement is technically only to use the 2022 single life expectancy tables. So by taking out more than what is required of them, do they satisfy the RMD? Yes, they do. You can always take more than your life expectancy, never take less. So if we use the old tables, we're taking out more than what is necessary. Therefore, we're still following the rules. That's why it's not a requirement. Is it something you want to let your beneficiaries know that they have the option to do? Highly recommended, yes. And then they move forward. Some financial organizations just made the decision, you know what, instead of waiting till people tell me they want to do this, I'm going to go ahead and do it all at once. So let's say they did take out more than what is required of them and their life expectancy payment, they used the old charts and they took out actually an additional $1,000 than what is required of them using those new single life expectancy charts. And they come into you and they say, hey, guess what? Why didn't you tell me I didn't have to take out this much? You know, then you're kind of dealing with the situation that we can't roll over money back in. And then you're kind of presented with the situation that you don't want to be in. I mean, just put it as simply as that. You don't want to get stuck in that situation because then they're blaming you for something. While it's not a requirement, it's still something you can let them know, and then they at least have that information at hand to be able to make the decision they need to make, because we can't put money back in those inherited IRAs. Remember, inherited IRAs, when you take a distribution, it is final. No putting money back in for anyone other than a spouse. Spouses get the option to roll over. Everybody else, a death distribution is final. We're done there. Great question. How long does the beneficiary have to do this? And we are going to go into more detail about that, but I don't think really there is a set time. I don't even think it has, I mean, there's nothing really that says they're required to do it by a certain date or they can't reset it, you know? It just says you're allowed to do a one-time reset is the specific rule. So anytime, I would say moving forward, you would just need to know that if they waited until like a future year there, you're still going to need to kind of backdate it to that 2022 time period and move forward from that, I would think too. Actually, you would need to backdate it all the way back to the start anyway, so it wouldn't really matter 2022 or later. Yeah, and we'll talk about that in more detail here when we do an example. So Here is an example. Frank died at age 80 in 2018. Frank's non-spouse beneficiary, Rose, was 75 in the year he died. In 2019, the distribution period that Rose must use is 12.7. The single life expectancy of a 76-year-old. For her distribution in 2021, Rose reduces that figure to 10.7. 1 year for 2020 and 1 year for 2021. Normally, Rose would then reduce her distribution period by 1 more year for 2022 to 9.7. The transition rule, however, permits Rose to reset her distribution period based on the new tables. So Rose still uses her age in the year following Frank's death, but she simply replaces the old life expectancy 12.7 with the new one, which is 14.1. So we look at the age of a 76-year-old, which she was in 2019, on the new chart and say, okay, it was 12.7, now we're dealing with 14.1. So instead of reducing by 1 to get to 9.7, we take that figure to get to 2022, we take 14.1 and now reduce it by the years we need to get to that 2022 one. And we end up at 11.1 instead of 9.7. So we reduce 3 years and get to that same figure. So notice we have to go back to that original date there, okay? We go back to the original date on that. So what we're gonna do is we're gonna look at that here. So remember, 12.7 is what she was working with as a 76-year-old previously. When we go back to this chart right here, 76, 14.1. So that would have been her amount in 2019 if we were already using this chart. We weren't already using the chart, but we're going to say we were to get us the figure we need for 2022. So we take that and we say 13.1 for 2020, 12.1 for 2021, and 11.1 for 2022. So we have to go back to that start. So if they were to come to us in 2023 and say, hey, I want to use the new chart starting now, that would be fine. We'd go back to this chart, 68, I'm sorry, we were 76. We'd still have to look in 2019, and then we'd just be subtracting by 4 instead of the 3 years that had passed. Is that everybody? So I know that's a more complex rule there. Do we need to do another example, or does everybody get that? All right. If for some reason something's not clicking and you haven't said anything yet, please feel free to chat that in, and I will go back and I'll do another example later, okay? So don't hesitate to say anything moving forward on that. So separate accounting. What is separate accounting? I mentioned it briefly before. Okay, I want you to imagine when you were a kid. How many of us have siblings? I have 2 older brothers. I am the youngest, so I am the favorite, right? That's how it works, right? The youngest is always the favorite. So did anyone have siblings? Do you have siblings? No? Anyone have siblings on here? Good. 4 siblings, I got yes. Anyone have play dates? Those of you that didn't have siblings, you had play dates with friends, right? Maybe not called a play date back then, but it was a play date. 2 older, 1 younger. Great. Okay. So imagine being a kid, or imagine your own kids here if you have multiple kids. We all know when it comes time to dessert time or anything like that, everybody wants to get what's theirs, right? Heck, I know I'm even still like that at this point in time. My husband, I swear, if we share a dessert, I have to literally split it down the middle, or I get 3 bites out of the whole piece of pie or cake, whatever we're dealing with. Okay, so I want you to think of separate accounting like that. And I'm going to use my family as an example here. Billy and Brett, remember, those are my brothers. So when my mom, when I was younger, and we had, we'll say a piece of, we had a cake or we had a pie, something like that. And my mom wanted to make sure none of us were complaining that we didn't get our portion of that cake. Well, they ate all the cake and I didn't even get to get any of it. Really, the person to worry about was always my dad. He would sneak in there at night though and eat the little pieces off, but that's besides the point right now. So we'll say for this case, she made a cake just for me and my 2 brothers, and she split it equally 3 ways. That was a 4-way split, but equally 3 ways there, okay? So she split that equally 3 ways, and then she put each person's piece of cake on a plate with their name on it. And they said, this is your cake. You do not get any more than this cake. No one can take anything from your portion of this cake. It is yours and yours alone. If you eat it all, you're done. There's no taking from the other plates there that you're dealing with. If you want to add whipped cream to that by leaving that cake there longer so you can add that whipped cream before you eat it, that's on you. Good. Okay. Separate accounting is very similar to that. Whenever you're dealing with it, it is pretty much just establishing these separate little accounts for each of the beneficiaries to where we can track those gains and losses easier for those beneficiaries. Therefore, whenever you're thinking about it that way, okay, so if we were to have just one whole cake and my brother Billy technically went in and ate 1/3 of his piece of cake, if it was all still put as just one, is it very easy to tell if somebody adds whipped cream to his portion or not? No, if there's gains or how much he lost. Does he still get his full 1/3 then of that whipped cream? See, it makes things more confusing whenever you still have it all in one joint account to keep track of things, especially if people are taking distributions. So by separating them into these little sub accounts with each person's section labeled, we're able to make sure each beneficiary gets their share. They never get more than their share. Once their portion is gone, it's gone. It's easy to track those gains and losses moving there. You are not required to wait for a beneficiary to say, please put me in a separate account. They don't lose it. They don't lose anything by being put in a separate account. This is something the IRS says you can automatically do upon the death of the IRA owner. Put it into your sub accounts, that's fine. Then later, you're probably going to want to request more information from that beneficiary to make sure you have a full customer on file with the ID number, everything like that. But you can separate them out into their own accounts without the beneficiary's request there. Once this is established, each one is considered its own thing. Therefore, that's why even if the spouse wasn't a sole beneficiary, they can now transfer their portion of it to their own IRA because they're the only person there. That's their full share. You know you can transfer that full amount. There is no document required to establish separate accounting. What type of transaction do we code this as? Coming out of the IRA owner's account, it's going to be a transfer. Going into the beneficiary's inherited IRA account, that sub-account, it's going to be a transfer as well. So there is no reporting there technically. It's just creating sub-accounts of that original account there. For deaths that occur on or after January 1st, 2020, only eligible designated beneficiaries and those non-beneficiaries of traditional IRA owners who die after the required beginning date may take life expectancy payments. So this separate accounting law has become used a lot less because people are not having to take those life expectancy payments. So we don't have to worry as much about separate accounting. I'd still say it's something highly recommended because it makes tracking things easier. It also makes sure you report it to the correct person. So for example, if it's all in the inherited or all in the IRA owner's account still, how are you going to make sure year of death reporting is done properly? It's harder to do and harder to manage and harder to make sure that it is accomplished properly, okay? So along with separate accounting comes the designated beneficiary. And this is a separate term, completely away from EDB, completely away from that information. This is a term prior to an eligible designated beneficiary. One reason I don't like that they use that word, eligible designated beneficiary, because we have a designated beneficiary specific to something that's not related to the beneficiary options. This is the oldest primary beneficiary as of September 30th of the year after death. This is only important if no separate accounting is established. Okay, so if separate accounting is established, then we don't have to worry about that. So I've got me and my two brothers, right? We're all named the beneficiary of this cake here. Well, my brother Billy's the oldest. He eats his share by the end of 2022. So that's the year of the IRA owner's death. That's the year the cake was made, right? He eats his share. He no longer has a share, okay? We're now at September 30th, and Brett and I don't split our money out in time. We make it to the end of the year, we still don't split our money out in time. What happens? Well, that means that all of our life expectancies would need to be determined based upon Brett's age. Now, in this example, we're going to pretend like my cousin, who's only a couple years older than us, he was the actual IRA owner. That would make us both EDBs. That's why this would matter moving forward. Okay, so it would only matter if we were EDBs who had to take life expectancy, who didn't establish separate accounting by the end of the year after death, and we're both still living there. So Billy, even though he was originally the oldest beneficiary, since he didn't have a balance as of September 30th, he's not included in that amount. Clear as mud? All right. Now, our beneficiary distribution options, what is this section for? So this looks like another similar chart. This chart was just expanded to add deadlines of when things are required of them, when they're expected to do things. Okay, lump sum distribution, 10-year rule, transfer to own IRA, distribute and roll over to IRA or eligible plan. Spouses can do that at any point in time. No deadline. Life expectancy payments, though. Look up here and see this is death on or after January 1st, 2020, and before the required beginning date or a Roth IRA. So if that's the case, that means that IRA owner hasn't turned 72 yet, hasn't begun to take those RMDs. A spouse gets the benefit of waiting until the later of 12/31 of the year following the IRA owner's death, or 12/31 of the year the account owner would have attained age 72. So if I were to pass away at age 33 right now, and we had a traditional IRA, which as you guys probably expect, I like my Roths. So Yeah, Roth all the way. Anyways, but I had a traditional IRA or my Roth. Remember, that's always before required beginning date. My husband would technically get until 12/31 of the year I would have attained age 72. Why? Because it's longer than 12/31 of 2023. So it's the longer of those two options there. The life expectancy for the first distribution year and for subsequent years is going to be determined using the spouse beneficiary's single life expectancy recalculated. So my husband would look at that chart every year if he kept it in an inherited IRA. So remember, if it's before RMD or a Roth IRA, they get to wait until that IRA owner would have been age 72 if they keep it in that inherited IRA. You might see this happen with spouse beneficiaries, because think of it this way: if they kept it in an inherited IRA and they were only 33 like me and it was a traditional IRA, if that spouse beneficiary wanted to take a distribution from that money to cover something, then he'd be responsible for an early distribution penalty tax, right? If he had it in his own IRA. But if he kept it in an inherited IRA, death is a penalty exception, so he'd always be able to take money out. And he wouldn't be expected to take money out until I would have reached 72. So a lot of people will keep it in there until they're at least 59 and a half. That way they have access to the funds without a penalty if they need it. Just an option available to them. It's really completely up to that IRA owner on what they want to do, or beneficiary there. So non-spouse beneficiaries who are still EDBs, they have a couple options available to them. Lump sum, 10-year rule. There's no really set date on that. You know, they've got the deadline of the 10-year rule. That's the only thing there. Life expectancy payments, though, if they're dealing with that, the payments must begin by 12/31 of the year following the year of the IRA owner's death. Okay, so they don't get the option to wait until that IRA owner would have reached age 72. The first year is going to be based upon the eligible designated beneficiary's life expectancy in the year after death, the IRA owner's death. And then every following year, we're going to subtract from 1 from that number. Remember, there are going to be special rules for those minor beneficiaries. They would start with those life expectancy payments and then switch over to the 10-year rule once they reach the age of majority. Okay. If it's not an eligible designated beneficiary, they only have lump sum and 10-year rule. And if it's a non-person beneficiary before RMD or Roth IRA, we still only have lump sum and 5-year rule. Beneficiary payments for a traditional IRA, death before RMD or Roth IRA. Remember, this is on or after January 1st, 2020. Here is an example. Jane was born August 12, 1955 and died before her RBD on July 16, 2022. Before her RBD, guys, her husband James and her 43-year-old daughter Ava are her only primary beneficiaries. By what date must James begin his beneficiary payments and why? What date must James begin his beneficiary payments and why? So our first step here would be to see how old Jane is, right? When she passed away. Anyone? So he must begin his payments by December 31st, 2027. Why? Because payments must begin the later of 12/31 of the year after Jane's death, 2023, or 12/31 of the year Jane would have attained age 72, which isn't until 2027. That is for James, okay? When must Ava have her beneficiary assets distributed? So Ava is a non-spouse beneficiary. Does she fit into any of the EDB categories? Does she fit into any of the EDB categories? Ava, for this purposes, she is 43, a 43-year-old daughter. So you guys are right. She is not an eligible designated beneficiary. So what is her only option?
The year after.
The 10-year rule. And so it's the year after is, well, that would be if it was life expectancy. So with the 10-year rule, when are the assets required to be distributed there? 12/31/2032. So we take 2022, add 10 to it. That's going to be the anniversary date. And then we go to 12/31 of that same year. The assets must be depleted by December 31st of the 10th year after Jane's death, 2032. Satisfying year of death RMDs. They must be distributed by 12/31 of the year of death. So even though the IRA owner passes away before taking their required minimum distribution, these still have to be satisfied for the year. We've already told the IRS this was due. The IRS expects that revenue coming in. Therefore, it is the beneficiary's responsibility to satisfy this RMD. We cannot report a distribution to an IRA owner after they are deceased. We have to report this as a death distribution in the beneficiary's name and tax identification number. There's no other option. It is required. If there are multiple beneficiaries, what you're going to be dealing with is, technically speaking, and this is controversial, and we'll talk about it towards the end, but technically speaking, they're required to split this amount. So if $1,000 is due, 2 beneficiaries get 50-50. Each one would get $500 of that RMD and required to satisfy it. Even if one took a full $1,000, the other one would still be responsible for his share. And this is, like I said, it is kind of something that people like to debate about on that one, what you're dealing with on the year of death RMD. All right, this next one shows how it affects the life expectancy deadlines if we're on or after the required beginning date. So this one is still after January 1st, 2020, but now we're on or after the required beginning date. So a spouse, still all the same options here. Difference being is they've already reached age 72, so they don't get to wait. They're going to be subject to that year after the IRA owner's death if they keep it in that inherited IRA. Now, one thing they do get to do is they get to use the longer of the spouse's beneficiary in the year following the death, or the IRA owner's single life expectancy reduced by 1. So they can choose, well, technically the amount that's required of them is the longer of the two. So if your spouse is younger than you, if the IRA owner is younger than you, then you might use their information depending upon whichever's longer. You go ahead and calculate it out to find out for sure which one. Now, if we use the spouse as the one inheriting the money, we would look at their single life expectancy in the year after death, and we'd recalculate it each year looking at that chart every year. If we use the IRA owner's death age because it's longer, we have to look at their age in the year of death, reduced by 1 for that first year because that's the first year we're going to take it. And then every year following, we continue to reduce by 1. So see how it could be different. It's normally only helpful if there's at least a few years in between those ages. So for example, my husband and I remember there's just a few months. That wouldn't make a difference there whenever you're dealing with something like that. The other types of eligible designated beneficiaries, who are those non-spouses, they still have the same date deadline, which is 12/31 of the year following the year of the IRA owner's death. That's when they must begin. The life expectancy is going to be used, the first distribution. It's going to still be the longer of the two. So they do get this benefit to use the IRA owner single life expectancy, not recalculated, or their own, whichever is longer. So in the case of me and my oldest brother, if he were to leave me his money, it might be beneficial, or I were to leave him my money, it might be beneficial for him to use my age rather than his own age. He would get a little bit of extra time there in moving forward. Same options for the not an eligible designated beneficiary and non-person beneficiary. What changes is instead of 5-year rules, we have that life expectancy payment. They have to begin 12/31 of the year following the IRA owner's death still. And there's no change in how that single life expectancy is calculated here. So, Edward, born on April 27th, 1944, died after his required beginning date on May 28th, 2022. His wife Joanna is the only primary beneficiary of his traditional IRA. By what date must Joanna begin her beneficiary payments and why? So remember, we're after required beginning date. So when must she begin her beneficiary payments and why? Well, does she get an extension? No, Edward was already 72 when he passed away. So December 31st of the year after death is when she's going to be required to take her first distribution. All right, why? Because payments must begin by the year after Edward's death if it's after RBD. He's already 72, there's no waiting. That was the only reason we got to wait earlier, is because the individual wouldn't have been taking RMDs himself. So now we went through all of the new information here. Death before January 1st, 2020. We've been through all of the hard stuff now. Deaths before January 1st, 2020. You're going to be familiar with all of the options that are available. The difference being is there's no eligible designated beneficiary. All non-spouse beneficiaries receive the same options. Non-person beneficiaries didn't change at all, remember? The same it was previously. Non-person beneficiaries, they used to receive life expectancy payments, and they now might only if they're an eligible designated beneficiary. So that is the only significant change you're going to see there. The other thing is there is a thing called the 5-year rule on all beneficiaries if it's prior to January 1st or prior to required beginning date or a Roth IRA. Okay, why is this information important? Why do you want to still be familiar with it, or at least know where to look for it? Because IRA owners and beneficiaries are not always on top of their game, right? They sometimes miss things. They might not have even known they were a beneficiary for years. I've heard stories about people coming in 10 years later saying, hey, I didn't realize that I was a beneficiary of this IRA. I need to start taking distributions. What are my options? Well, then you have to look at what their options are, how long has passed, what they need to do to satisfy it. Mostly, I'd say talk to a competent tax advisor moving forward, but that's one thing that you have to deal with moving forward, okay? So these are important things to know, okay? Now, before we get into our examples here, which I want you guys, you're going to do those on your own. I want to do a quick review here. So, who gets the option for a lump sum distribution? Who gets the option? What type of beneficiary?
Oh,
Very good. Every type of beneficiary gets a lump sum distribution. Who, moving forward, January 1st, 2020, gets the 10-year as an option? Who gets the 10-year payout as an option moving forward? Eligible designated beneficiaries do. Who else? Remember, all person beneficiaries get the 10-year payout. If you are a living, breathing human being, you get the 10-year as an option there. Who gets the transfer or rollover option? Spouse. Yes. Spouses are the only ones that get the transfer or rollover option. Okay. Who is the only one that gets the 5-year payout? Or what? Hint, hint. Perfect. I'm getting non-person. When does that IRA owner have to have died if the non-person gets that 5-year payout? Correct. Before RBD. You want to know how I remember that one? Is the IRS starts to get payments if you're having after required minimum distribution age, right? So after RBD, they start to receive this revenue coming from that IRA owner. Do you think they're going to want that revenue to stop? So the 5-year option goes away for that non-person beneficiary afterwards. Honestly and truly, with the non-person beneficiary, I think I've rarely ever heard of someone choosing to go with a life expectancy payment instead. It's more so people are like, give me the money for the charity, move on, we're done with it, right? So those are the ones that I would say remember on. Now I want you all to tell me who is an eligible designated beneficiary. Here are my 5 things that are an eligible designated beneficiary. Just name one of them.
spouse.
Very good. All right, I got spouse taken. Minor child of who? Can it be any minor child? There we go. Minor child of IRA owner. Chronically ill individual, yes. Disabled. And what is the last one? Not more than 10 years younger, okay? So remember, it's very specific the way that's worded. So what does that mean? We can do older than the IRA owner. We can do between 9 and 0 years younger than the IRA owner, but we can't do more than 10 years, okay? So that means adult children are always going to be not eligible designated beneficiaries, okay? Always know if you're dealing with an adult child, it's not an eligible designated beneficiary. When I say adult child, okay? All right, guys, we have some exercises here. Let me look how many we have. I want you guys to do this on your own. Don't tell me your answers until I get us back together. We're gonna have 5 minutes to do this really quickly. And then we're all gonna get back together and tell me what your answers are. 5 minutes starting. Well, that didn't work. All right, there you go, starting now. Remember, all of these questions are going to be in your booklet that you have. There's actually 3 questions on this one that you need to answer. All right, so on to our answers. Macy Nuts, I always say Knutson, I know it's Knutson, was born May 20th, 1929 and died on June 18th, 2022. Her primary beneficiaries of her traditional IRA are her husband, Carl, and her 66-year-old daughter, Jillian Andrews, and her favorite charity. Which options will each beneficiary receive? So first, let's talk about her husband. So remember I talked about there's things we need to know. First question being, did she die before or after January 1st, 2020? She died after. So what are the options that she's going to receive? We also need to figure out how old she was. How old is she? She's after RMD age. So what are her husband's options here? Great. Carl gets all options because Carl is a spouse. He always gets all options no matter when. He always gets all options. Jillian is her adult daughter. What options does she get? Very good. 10-year rule and lump sum. What options does our charity get? So we are after required beginning date. So we need to make sure we do the ones after required beginning date for a non-person. Remember, once we start taking those distributions, they expect to keep taking them. And with a 5-year payout, are we required to take a payment each year? No. So the only ones available to the beneficiary charity here is going to be the life expectancy payment and the lump sum distribution. 5-year rule is not an option because we're after required beginning date. All right, now we got Jack Hansen.
Can I have a question right before you go
Yeah.
on the next one? For the spouse, can they still do the transfer if they're not the sole primary beneficiary?
Good question. What would they have to do in order to do the transfer?
I mean, isn't that the distribution and rollover?
Pretty much. So the spouse would have to either distribute or roll it over, like you said, or we could establish separate accounting between those three, and then they could do the transfer.
Okay, gotcha.
Perfect. So now we've got Jack Hansen, who was born April 14th, 1989. Guys, do you think 1989 is after required beginning date? Hint, hint. All right, they died May 15th, 2022. Primary beneficiaries of his Roth IRA. Oh, we're dealing with a Roth. So guess what? It's always before required beginning date, isn't it? Are his wife, Sarah Hansen, his daughter, Emma, who was born October 17, 2013, and his favorite charity. What options will Sarah receive as a spouse? Spouses always receive all of them. Good job. Always receive all of them, no matter what. Now, Sarah would need to establish separate accounting. Make sure that is established in order to transfer. But they would receive that option if they handled that properly, okay? Emma, the daughter, who was born in 2013, we're now in 2022. So that makes her a minor child of the IRA owner. What are her options? Very good. 10-year rule, life expectancy payments, and lump sum. She is that eligible designated beneficiary until she turns 18. Very good. Now our charity, what are our options? There we go. Lump sum and 5-year rule because it's always prior to required beginning date for a Roth IRA. Marilyn died age 83 in 2018. Marilyn's non-spouse beneficiary was Jeff, who was 79 in the year she died. Using the transition rules, what is the divisor Jeff will use to calculate his 2022 beneficiary payment? Got one answer. I know more of you know this answer. Are you awake? Wake up, wake up, wake up. We're about to take a break. All right, the answer is 8.2. Why? Because we need to go back to that chart. 79 in the year she died. So we need to look at 80 would be his first year of distribution there in 2019. Figure it out on that chart from that point forward, okay? Okay, everybody, let's take a 10-minute break here. Is 10 minutes okay with everyone? And then we'll come back and hit the ground running on these last two sections, okay? Stretch, wake up. Go out into the cold, wake yourself up. All right, everyone, welcome back and welcome to our last round here that we have prior to being done today. We have 2 more sections to get through, and we're going to go through them pretty quickly. There should be some questions, or you might have some questions along the way. Feel free to slow me down if you need to, but we do have these 2 sections to get through. We're doing pretty good on time right now, but I just always like to make sure we have plenty of time for questions too at the end, if anyone has any. So this first section is on advanced portability. Sorry. After this section, you'll be able to summarize the restrictions. My goodness, something's in my throat there. On the movement between IRAs, we're going to talk about conversions. What are they? Where does the money move between? What are we dealing with on those conversions? What happens with them? Goodness. We're going to explain the effect of withholding on a conversion. What happens to our reporting if we withhold on it? How do we have to change things moving forward? And then finally, we're going to recognize the portability options when moving from an employer-sponsored retirement plan to an IRA. Ooh, I think that bug's finally out of my throat there. So let's go. We talked yesterday about the difference between a rollover and a transfer. A rollover being that IRA owner gets their hands on the money in the middle, right? Right? It's always moving between like and like accounts. We're going to traditional or Roth to Roth. The money is moving between like and like accounts. The same color of cup. You're going from one to the other. The IRA owner gets access to those funds in the middle, though, so they can do whatever they want with the money in the middle. That's what makes it that rollover. If they put all of the money back into their account that they distributed on that rollover, then technically it's that tax-free movement of money. They moved it from one account to another, and they're not going to be subject to any taxations for taking that distribution because they put the money back into the account. So that's a significant difference there with that rollover that you're dealing with. The importance is they put the money back in that they took out. That includes any withholding they had withheld. So if we did a $10,000 distribution, 9,000 of that they actually received, 1,000 of that went towards withholding. They put the full 10,000 back into their account. Then we have a rollover that is tax-free there. We're not worrying about anything there moving forward. Remember that the rollover is subject to additional things because the IRA owner has access to those funds in the middle. They are subject to a 60-day rollover rule. The IRS does have the authority to waive this rule for certain reasons, and they do have some things lined out for this purpose of reasons why they might allow for this. And if you fall into certain rules, you might get an automatic waiver, as well as you might just be able to self-certify it. If nothing else, everything else fails, then you have one option to apply for a private letter ruling. These are the 3 different ways that you could get a exception from that 60-day rollover rule. As a reminder, the 60-day period starts the day after the IRA owner receives the assets. So if you hand them a check today, then tomorrow is day 1. If you mail them a check today, then the day after they receive that check is going to be day 1 for them. It starts with the distribution. Okay, it is based on the distribution that the 60-day goes, and it's a day after they receive that money. So that's how the 60-day process is figured out there. Now, like I said, these are the 3 options. So let's talk about when each one will apply here. There is an automatic waiver of the 60-day rule. automatic waiver, pretty much this is only granted if the IRA owner does everything right. The IRA owner did nothing wrong. The only reason that the 60-day window wasn't met was due to some form of financial organization error. The financial organization didn't do what they were supposed to do. So in other words, the assets were received within that 60-day calendars of the distribution. The IRA owner followed procedures. They made sure they put the money in the right account. They made sure to fill out the form properly. It's not more than one per 12 months. It follows all the rollover rules. It is due strictly to financial organization error. If the assets are deposited within 1 calendar year from the beginning of the 60-day deadline, it can use this automatic waiver of the 60-day rule. And the last thing is, it would have been valid if it deposited as instructed. So in other words, if the IRA owner comes in with the money's timely, gives you that money, says, I want it to go into my traditional IRA, and you put it into their savings account instead, that is not the IRA owner's fault that it didn't get input in timely. It is the financial organization error, and they can correct that error by having the automatic waiver of the 60-day rule, roll over the funds after all, okay? So this waiver is automatically granted if all are true there. If all of these things are true. Self-certification, I like to think as the little way out of it for those IRA owners. What this allows for is the IRA owner to say, you know what, yeah, I know I didn't meet the 60-day rule, but it was due to a valid reason. It was due to an acceptable reason according to the IRS standards. In 2016, the IRS issued Revenue Procedure 2016-47, superseded by Revenue Procedure 2020-46. This describes new options for those IRA owners and plan participants to self-certify that they qualify for relief from the 60-day rollover rule. This applies to IRAs, 401As, 403As, qualified retirement plans, 457B plans, those governmental 457B plans. What they're doing is the IRA owner is saying, based upon me meeting one of the reasons that you have outlined in one of these procedures, I have met the qualifications to waive the 60-day rollover rule. The financial organization may rely on this information provided by that IRA owner unless they know something to the contrary. So if they know that what they're admitting, hey, they say it was due to plan administrator or financial organization error, and your financial organization didn't make that error, or, you know, then you've got questions to ask. Was it somewhere else that made this error? What happened exactly? Or, you know, one of my favorites of the reasons that the IRS allows for is going to be the IRA owner was incarcerated. If that's the case, you get that waiver of the 60-day time period. Or another one is, it says a member of the IRA owner's family was seriously ill. Well, how far does that family go out? How far? It doesn't say specifically. So you could say my second cousin on my brother's sister, you know, my brother's wife's side over there. That is a family member, right? So that's one of the interesting things about that one is that there are set reasons lined out in these revenue procedures that they could use that for. Ones that make a little more sense you're dealing with, like the postal errors. Check gets lost in the mail. You sent it, you have proof you sent it. You can't help that it got lost in the mail there. So that is one of the reasons, well, several of the reasons that you can use for this self-certification. What happens is it allows individuals to report rollovers as valid unless later informed by the IRS. Now, we wouldn't report this in the normal in the normal rollover box of that box too. Instead, we actually, I got click happy there. We'd actually report it in box 13A. where you note postpone/late contribution. This was where we would put a self-certified rollover. And then in 13C, you would put SC for self-certified. A copy should be kept in the IRA owner's file of their self-certification request, noting that information, and should be available upon request if ever asked for it. The other thing is that this must be done as soon as possible, as soon as reasonably feasible. So if you say the reason I didn't do this rollover was due to a family member being in the hospital, your family member gets out, 3 months passed, you still haven't done anything with it, the IRS is going to ask questions about that. That doesn't make sense, right? You had 3 months after your excuse to fix this and you haven't yet. Why? So you want to make sure it's done as quickly as possible. 30 days after the reason no longer applies is deemed to satisfy that. So you're still in that 30-day range, you're okay there. Remember, like I said, we report normal rollovers in this box too, but these self-certified ones get reported in a different box there. A private letter ruling. This is for those big bucks the IRS wants to roll in, right? With a private letter ruling, what you are doing is you are requesting a personal request to the IRS for them to approve something for you. You write this letter requesting this, saying, hey, I know I don't meet the rules, I don't meet the reasons, but I want to request that. Along with that, I'm giving you my $10,000 fee in order to get that accomplished. It used to be a tiered fee structure where, according to how big the request was, you'd have to pay more money. Now it's just a flat $10,000, no matter what you're asking for. I don't know about you guys, but $10,000 sounds like a lot of money to me. Okay, but I guess if you're dealing with hundreds of thousands of dollars, depending upon what you're requesting a rollover for, it may not be like much, you know, if you're dealing with hundreds of thousands of dollars in taxes or something like that, $10,000 may not be that big of a deal, okay? So what this does is private letter rulings are approved for the individual requesting only. So what we can do is we can look at previous private letter rulings and decide, hey, do I want to apply for one based upon if this one was approved or not? But we cannot use it for our own personal guidance. We cannot use it moving forward to help make a decision if it will be allowed personally for an IRA owner. So with this, what you might see is, say John Doe requests for private letter ruling for missing his 60-day window because his dog passed away. He feels like that's a valid reason. He pays that $10,000 fee, and you know what? The IRS, at the IRS, he found somebody who is a really dog-friendly individual, and they said, you know, I think that's a valid reason. So they approve it for John. Does that mean that if his sister later has a dog pass away and misses that 60-day window because of the same thing, that she can have that done? She can roll her money back in? No, it is for John only. Now, Sarah, his sister, might choose, because of John getting this approved, to submit a request to the IRS as well, pay that $10,000 fee as well, and try and get it waived as well on that amount. The only amount that's going to be allowed to be rolled over, though, would be the distributed amount. So they can't put additional money in because this has been approved or anything like that. Now, you may think, well, what if they deny this private letter ruling, right? They say, you know what, your dog passing away, well, it's sad. It's not a reason for you to miss this. They give you the $10,000 back, right? No, you pay that $10,000 fee no matter what. The IRS keeps that money. They're not going to give it back to you. It's staying with them moving forward. So those are the ways to get around that 60-day window if you mess up on that. We also have the 1 per 12-month rule. This one refers to IRA to IRA movement, right? Like to like. Only one type of account means we only get one rollover per 12-month period. Okay, one type of account, one rollover per 12-month period. We cannot roll over more than one distribution per tax year per taxpayer. Does that mean that we can't take more than one distribution each year? No, we can take as many distributions as we want. We can just only choose one of those distributions to put the money back into the IRA and count it as a rollover contribution. Now, on the contribution side, technically it could take us 3 rollover contributions in that 60-day window to put the money back in. So for example, we take $9,000 out as a distribution. One distribution, I could put that back in 3 separate payments of $3,000, $3,000, $3,000, as long as I'm in that window. But I couldn't take $9,000 and then later take an additional $2,000 and then want to roll over $11,000. Makes sense? And this is per taxpayer, per tax identification number, not per IRA, not per financial organization. This is, my name is Elena Drope. I'm allowed 1 rollover per 12-month period. Not 1 in 2021 and 1 in 2022, 12-month period. So if I take one today, I can't take another one until that same day in 2023, okay? The RMD restriction is another important thing. Remember, RMDs are always going to be the first money out of our IRA whenever we're dealing with RMDs. So whenever you have a traditional and a simple IRA, you want to make sure that IRA owner always distributes that RMD prior to doing anything else. So if an IRA owner who's over the age of Rmd age comes in, they say they want to do a conversion, or they say they want to do a rollover, they say they want to do anything other than distribute an RMD, you ask the question, have you taken your RMD for the year? Have you satisfied that? We would first distribute that RMD and then roll over whatever amount they want to after that. So in this case, let's say that they come in and they request a $20,000 distribution. Well, their RMD for the year was $2,000. So if they have not satisfied their RMD for the year, the only money that they could technically roll over would be $18,000. Okay, the $2,000 of the RMD would have to remain out of the IRA. We couldn't put it back in. They could do the distribution all at once and just not put back in the $2,000. That is acceptable. But the main important part here is that you cannot put the money back in of that RMD amount. This brings up another issue that has occurred since Secure Act. An individual may be taking a distribution at the same time as they are eligible to make a contribution, right? Because we can make those contributions after Rmd age now, as long as we have that eligible compensation. So if we can do that, technically, my RMD is $2,000. I could technically still make a $2,000 contribution to my traditional IRA as long as I have the eligible compensation to support that. But it would be called a contribution. It would be new money, and it would be taxed on the actual distribution going out. It wouldn't be that non-taxable event that a rollover is, okay? Okay. Now, conversions. We talked about conversions. Conversions are going to be that money going from a traditional IRA going to a Roth IRA. It is a taxable event. There are 2 different types of conversions that you can do, a direct conversion and an indirect conversion. What this is you are taking pre-tax money that's in that traditional and simple IRA, and you are making it taxable in the year that you take the distribution, and then you put it into our Roth IRA, and it's now after-tax money. So we make the money a different type of money by being taxed at that point in time of the conversion. It is a reportable taxable transaction. When converting assets to Roth, the IRA owner must pay tax on all pre-tax assets included in the conversion in the year the assets leave the traditional or simple IRA. Not in the year that it's actually put into the Roth, but in the year that they leave the traditional or simple IRA. Although the assets are taxed, if it's properly converted, they're not going to be subject to that 10% early distribution penalty tax. So we can go through two different types of conversions. Like I mentioned, a direct conversion, which moves like that transfer from one to the other. Financial organization does the work. IRA owner doesn't get their hands on it. Indirect conversion, the IRA owner gets their hands on it, makes things muddy in the process. They can do what they want with the funds in the middle, and then they convert it to that Roth IRA. Even though that indirect conversion moves very similarly to a rollover, and it's going between IRA to IRA, they are different types of IRAs. So it's not subject to that 1 per 12-month rule, but it is still subject to that 60-day time period because we have a distribution that's actually reportable, and we have to get it back in within 60 days. They don't want to give you as much time as possible there to do that. They want you to get it done quickly. Now, depending upon the IRA owner's age, a conversion could result in a substantial increase in after-tax distributions at retirement. If somebody's wanting to do this, they're going to want to consult with that competent tax advisor. Something important to know is there's no undoing a conversion at this point in time. Once a conversion is completed, it's stuck, it's finalized, you have that money you have to pay taxes on. There's no saying, uh-oh, I didn't realize taxes were going to be that much. There used to be a way to do that. There's not anymore. So it's something we highly suggest talking to a competent tax advisor about and saying, is this a valid option for me? If not, you want to make sure you know ahead of time. Let's see here. Okay. So just like a rollover, we are unable to convert an RMD. Why? Because the IRS wants to receive that taxable income. Well, you may think, hey, if we're taxing it in the year that it's distributed, then technically they are receiving that taxable income. But what happens if we convert that amount? That pre-tax income becomes Roth money. And with Roth money, if we wait a certain time period, we get that tax-free money, right? So the IRS says, you know what, I'm not going to let you gain additional interest on this money that should have already been taken out of the IRA. No, you're going to take it out, and it's going to stay out. That's what you're dealing with, those conversions. So again, someone comes in requesting that diversion or conversion, then you want to make sure you say distribute your RMD first and then convert the money. Or just make sure that the amount that it needs to be done for the RMD isn't converted over. All right, 1 second here. Converting and withholding is the next section. So think about it this way. Whenever we convert, we are making that taxable distribution, right? Which means we have to provide the option to withhold if they want to. Those taxable distributions, we always want to provide the option to withhold. If the individual is under age 59 and a half, we might have to do 2 separate 1099-Rs for this purpose. Why? Because the amount that's withheld is not going back into the IRA. And we need to code that as a code 1 because there's no technical reason why you didn't put it back into the IRA. There's no penalty tax exception. This might be subject to a penalty tax depending upon your age there. We've got that code 1, remember, and if you don't have another reason for it. The amount that is directly converted, remember, we will use code 2. We have peace with the IRS. We have agreed that this is an acceptable reason for a penalty tax exception. So you're going to have 2 separate 1099-Rs for individuals who are converting and withholding. One to report the withholding amount only and code distribution 1, and one to report the amount that was converted with a distribution code 2. If you're over 59.5 or older, remember everything's reported as reason code number 7 there. One second, I have a question here that I need to send over. Okay.
So is that to say that you can't use 2 simultaneous codes on a 1099-R?
Unless they're for the same actual distribution. Yes, so the same money. So you're correct. So technically, whenever you think about this one, it's for 2 separate portions. So code 1 only applies to the amount withheld, and the code 2 only applies to the amount that was directly converted. Other times you might have a reason code for like an excess contribution or something where technically it's an excess, so you're going to use the excess code that applies, but it's also a code 1 because you're under the age of 59.5. That all applies to the same distribution, so you could use those same 2 codes at the same time. Another time you might see 2 codes for an IRA owner would be the first part of the year they were under the age of 59.5. Taking distributions as a code 1. Later in the year, they took distributions as a code 7 because they're now over 59.5. So you'll see these 2 1099-Rs for that information. Makes sense. So this is one of the more complex ones whenever you're dealing with that converting and withholding. It's important to remember, like I said, it only really affects IRA owners who are under the age of 59.5 because they automatically have that penalty tax exception for that amount that's directly converted. Now, say an individual makes up the amount later, then you're going to be dealing with, it's not a direct conversion. They're indirectly converting the money on that portion. So you're still going to have already withheld that amount, reported at that amount, and then you're moving forward from there. Our Roth loophole. This is also familiarly known as a backdoor Roth contribution. What this is for, remember we talked about we have those modified adjusted gross income limits to prevent Roth individuals contributing to a Roth IRA if they make too much money. The IRS says you already make too much money. You don't get to get that tax-free money. We want you to pay on your tax. We want to pay taxes on your interest and things like that. So you don't get to use a Roth. Individuals saw a loophole in the mix whenever they were doing this. Because we have those modified adjusted gross income limits on contributions of new money, but we don't have them when we're moving money from a traditional to a Roth, they figured out that if they were to put the money into a traditional IRA as a non-deductible contribution already and immediately convert the money to a Roth IRA, they're not going to have any income restrictions on that conversion. Therefore, they could put the money as a traditional IRA contribution and immediately get them into the Roth IRA. Start making that tax-free money, even though the government said you shouldn't. This is something that has been a big controversy for a long time, and the government is looking to get rid of this this loophole. They're looking to stop it. At this point in time, it's still allowed, but it should be noted that this might become an issue later on in life if they're, the IRS were to go back and say, yeah, all the ones that were previously allowed aren't allowed. I highly doubt they do something like that retroactively. It would probably be more so moving forward. You're no longer allowed to do that. Okay. So, like I said, this is a little bit of a loophole to get that money in. Something people forget about is that traditional and simple IRAs, all of them are considered that cup of coffee, remember? And with that cup of coffee, if there is pre-tax and after-tax money anywhere in that, then each distribution comes out pro rata. So in other words, I get a little creamer, I get a little coffee and sugar every drink. I can't say I only want the black coffee out of that because it's all mixed together now. So even if they set up an individual traditional IRA just for their non-deductible money, if they have pre-tax money anywhere else, it's going to be taxable there when they move the money over. They're going to have a portion of that comes over as taxable money there. Okay, so it's just something to note there that people might not be expecting whenever they're dealing with that. Again, it is a conversion. So if anybody's going to do a type of transaction like this, tell them to talk to that competent tax advisor. It's not your responsibility to coach them through it. It's not your responsibility to tell them that it might not be allowed or anything like that. It is completely on that IRA owner between them and their competent tax advisor. Employer-sponsored retirement plan to IRA rollover rules. We do have eligible individuals may roll over a distribution from an eligible employer-sponsored retirement plan to a traditional Roth or simple IRA. So money coming from their retirement plan to any type of IRA there. These are going to be in the following categories. You've got your qualified retirement plans. Those are the 401As and the 403As. These are generally divided into defined contribution plan, which is for DC, and the defined benefit plan. What's the difference between the two? The defined benefit plan are going to be more so what you see with the movies talking about the old days, as they call it, where a person had a pension that they were set to receive. They worked for a company for a set number of years, and they were told that upon retirement, every year following that, they would receive this amount of money. That pension, the guaranteed thing. A lot of these have gone away. Some of those even got messed up in the process because companies shut down, things like that. There are still some out there. The defined contribution plan would be the employer agrees to contribute a certain amount to that employee. You've got money purchase pension plans, profit sharing plans, 401Ks, thrift savings plans. Those are ones that you see very regularly. We also see that 403B or a TSA pretty regularly too, and a governmental 457B plan. These are all things that are going to be allowed to be rolled over to an IRA. I bring this up every time because to me, this is my favorite resource and I like to help people get there. So I'm going to show you in publication. Oh, sorry, I got my annotations up still. In publication 590A, when you go into that publication, scroll to page 22. This is my favorite chart provided by the IRS here. It tells you exactly you can roll money from and roll it to what. It goes through step by step. We can roll money from a Roth to Roth, but look, it says we can't roll it into anything else. That falls in line with what we talked about, right? Roths are the black hole. Once it's in a Roth, it can't go into anything other than a Roth. Notice here's all the qualified retirement plans. We can roll from qualified retirement plan pre-tax going into these, okay? We can roll from a traditional IRA going into a qualified plan. So notice that these go through each of the categories. There are some additional notes and asterisks down at the bottom that make sure to tell you, hey, you have to do these things prior to doing it. Or only one rollover is allowed. You must include it in income, things like that. So these are all important things that you need to know. This rollover chart kind of takes me down everything. So whenever somebody comes in and they say, hey, I want to move money from a qualified retirement plan, you can ask them, what type of qualified retirement plan? Where are you going to? And get to the answer you need to by looking at this chart. Rather than looking at some of the other options that are available to us, which to me make it a little more complex. So let's talk about those other options, because for some people, they make it a lot easier. This is the other option I was referring to. This chart to me has always been extremely confusing, but I am not a visual learner like that. To me, if you have it in words, that makes sense to me. Again, you guys know I'm an English major, so words make sense. Drawings, on the other hand, sometimes it's a little harder for me to follow. But what you see here is if we're doing money coming from an eligible retirement plan, it notes that no Roth assets can go to a traditional IRA. It notes that Roth assets can go to a Roth IRA, okay? You can also have all other assets go to a Roth IRA in regards to it. No Roth assets can go to a simple IRA. So remember, we just talked about the only money that Roth can go into, even if it's eligible retirement plan, Roth eligible retirement plans can go into another Roth. That's the only way they can go. They can't go into anything else. A Roth, on the other hand, can't go anywhere, okay? So no Roth assets can go to that simple IRA. We can have pre-tax money go into an eligible retirement plan. Remember, I showed you that line there on that chart. Pre-tax money can go into eligible retirement plans, but no after-tax assets. And then simple IRA, it can go into eligible retirement plan. Notice there is the stipulation here of after the 2-year waiting period. If we don't have that met, then we cannot do it, can we? No. We have to have that 2-year period met on the simple IRA. So those are the rollover rules and how the money must move, what you're dealing with on that. Are there any questions? Anything you'd like me to go over in more detail on portability? Okay, so remember page 22 of publication 590A, if that works well for you, that's a great resource there to refer to. Okay, moving forward. The next section we have finding answers to commonly asked IRA questions. Feel free to chat any questions we have on anything previously at this point in time too. So after completing this section, you will be able to review commonly asked IRA questions and learn about the resources available to find those answers. So in other words, these are the questions that we get asked regularly. And not only do we get asked regularly, but we have customers, and you all know the customer that comes in and it says, well, I don't believe you. Where is this in the resources? Where does this say specifically I can't do that? So what we're doing in this section is giving you that information, not only about what the answer should be, but what rules were applied to come up with that answer. So question number 1, I reviewed my quarterly statement and noticed that the contribution I made on April 8th, 2022 was listed as a current year contribution. I wanted it to be for the prior year. Will you change the year so the contribution is reported for the prior year? Everyone take a second here and talk about it a little bit in your group, or just think about it for a little bit here to try and figure out what exactly you're dealing with, okay? And I'm going to let you take just a minute here before we move to the next slide and discuss that. So will you change the year so the contribution is reported for the prior year? So is this ever possible? Is it not? Why and why not? Good. All right. So answer number one. The way you should handle this first is, let me review that paperwork. I need to see exactly what occurred at the time you requested to make that contribution. If it shows that you indicated in writing a prior year contribution, then I can correct the contribution as being for the prior year. If the paperwork doesn't indicate the prior year, then I can't correct the contribution. This is one of those reasons it is imperative to have that paperwork when you have those prior year contributions to back yourself up. It's one of the things that I told you about. If you do contribution forms and they're designating that year, make sure you have them initial beside the year they're designating. That way they can't argue that you wrote that information in. So you want to make sure that they have that paperwork properly done, or something noting in writing that it is a prior year contribution, okay? They want to be able to prove this information. But even if they didn't fully contribute for the previous year, and we're still in that contribution time period, I can't change that if they didn't indicate prior year. It has to be at the time of the contribution. You have to dictate that information. Why? Because it's irrevocable. You're irrevocably designating that it's a prior year contribution. I can't later change it to a current year. And I can't later change it to a prior year if it's a current year. Those are designated at the time of the contribution. Where can this information be found? Well, it's in publication 590A, that publication you just went to there. And notes that contributions made between January 1st and the tax return deadline should be allocated either to the current year or to the prior year. So we have to make sure we're designating where it's going. Without direction, we always assume and report that it is a current year contribution. So note specifically what it says in the publication 590A is in the little picture below. Designating year for which contribution is made. If an amount is contributed to your traditional IRA between January 1st and April 15th, you should tell the sponsor which year, the current year or the previous year, contribution is for. If you don't tell the sponsor which year it is for, the sponsor can assume and report to the IRS that the contribution is for the current year, the year the sponsor received it. So if you need that proof, it's in that publication 590A giving you that proof, okay? It's actually on page 10 of the 2019 Irs publication 590A if you're curious where exactly it is there, okay? Are there any questions on that one? Okay, question number 2. My twin daughters were born earlier this year, and my savings account has taken quite a hit after paying medical bills and purchasing all the baby supplies. I've heard that I can take a tax-free IRA distribution to help pay for some of these expenses. Is it too late to take a distribution for this reason? So think about the question, what it's asking, what it's asking to do actually, and what are the options available to this individual here? Good job. Feel free to chat it in whenever you've got the information. So you guys are exactly right here. The Secure Act allows for individuals to distribute up to $5,000 per qualified birth and adoption to cover expenses. And it does have to be within that 12 months period on either side of birth. You're exactly right. So it does have to be in that time period. One thing that is different about what this individual is asking for, though, is he's asking for a tax-free distribution. This isn't possible due to birth or adoption. They're only allowed to get out of that penalty tax, okay? So we don't avoid the 10% early distribution penalty tax because we're taking that $5,000 for a qualified birth or adoption. So as long as we take it within 1 year of the birth of your daughters, it will be that penalty tax free, but we would still be responsible for covering the taxes on that. Someone else brought up the ability to repay that money, and that is a great point. You would also be able to repay that money if you wanted to, and at which point, if you've already paid the taxes on it, you would get a tax refund for the amount of that you were taxed on. So there's a way kind of around getting the taxes on it, although it would be subject to it, and then you'd later have to get it in a refund way. Somebody else asked, Andrew asked here, could you take 5,000 each as well? Yes, because it's actually 2 children there, 2 births there that you're dealing with. So this is the way it's worded. According to Irs Notice 2020-68, a qualified birth or adoption distribution is still includable in gross income, but it is not subject to the 10% early distribution penalty tax. The distribution must be taken within 1 year of the date of birth or adoption. So this is the exact wording of it. Qualified birth or adoption distribution is includable in gross income, but is not subject to the 10% penalty additional tax under 72T1. A qualified birth or adoption distribution is defined as any distribution from an applicable eligible retirement plan to an individual if made during the 1 year period beginning on the date of which the individual is born, or the legal adoption by the individual of an eligible adoptee is finalized. So here, this actually goes into more information stating it has to be actually when the individual is born. So this one actually goes into more detail saying it can't be 1 year before, it has to be on the date which the child is born here. So it kind of actually has added more information to what we previously knew on that there. Okay, so why am I getting a Form 1099-R if I rolled over assets from one IRA to another IRA? How do I prove that I completed a rollover? Why am I getting a 1099-R if I rolled over assets from one IRA to another IRA? How do I prove that I completed a rollover? Remember what we talked about with rollovers. It starts with an R, ends with an R. A rollover between IRAs starts with the distribution because it is actually a formal distribution. Money is coming out of that IRA. If it is completed within the 60-day time window, rolled over the 60-day time window, that's when it is considered a rollover. We still must report the distribution on the Form 1099-R. Why? Because we don't know that they're actually going to roll the money back in. or do it within the time window. We don't know what they're going to do with the money for sure, unless it's already back into the account. That's why you report it when it comes out in case, because the IRS wants to be able to tax them on the money if they don't put it back in. The receiving financial organization will generate an IRS form 5498 to show the rollover contribution. So this information will be provided to that individual with that 5498, noting that information. Now, something that happens regularly here, honestly and truly, is you have an individual that might take a distribution at the end of a year. And so they kind of freak out about it a little bit because they're not going to receive the 5498 until the next year, right? So whenever they go to do their taxes here for 2021, they took the distribution in 2021. So we're going to have that 1099-R showing that. But the 5498 showing that it went back in doesn't come until 2022. It is that IRA owner's responsibility to report this on their 1040 lines 4A and 4B, okay? By reporting it on that information, showing that the money was rolled back in, you can include a separate note noting, hey, it was rolled back in 2022. You know, here's my rollover contribution form, or however you want to handle it there. But as long as it's rolled over in that 60-day time window, and you report it on that 1040, let the IRS know that information, there should be no issue with it. But you do have to let them know that information. So, according to Form 1040 and 1040 SR instructions, you must include the amount of the distribution that you rolled over on line 4A and to roll over next to line 4B. Okay, that's how we tell them it was a rollover. If you rolled over the total amount, you will also enter 0 on line 4B. Why are you saying nothing is taxable here? Okay, I won't read through all of that information for you, but you can take time and read it whenever you want there. Just to note, the first picture is for the 2019 instructions, Form 1040, and it's on page 23. Second picture is also on page 23 of that Form 1040. And the third picture, that goes from page 23 and 24 for your information. Okay. So notice it does go through all of the details telling you, for example, the tips are always important things to read. So I will go ahead and read those for you, but special rules may apply if you received a coronavirus-related distribution from your individual retirement account or arrangement on or after January 1st, 2020. It lets you know, see publication 590B for that. It also says special rules may apply if you received distribution from your IRA and your main home was in one of the federally declared disaster areas eligible for these special rules at any time during the incident period. Special rules may also apply if you received a distribution on certain dates. It's talking about those federally declared disasters. Why? Because both coronavirus-related distributions and federally declared disasters actually get a longer time period to roll money back in. So that is important to note, and they are reported slightly differently too, whenever you're doing things on the distribution or on the rollover side, on the recontributing side there, because it's a repayment, then it's not a rollover. Question number 4. My 2021 distribution was reported incorrectly. It was a qualified charitable distribution and wasn't taxable. So my IRS Form 1099-R shouldn't show that $2,674.83 distribution as a taxable distribution in boxes 1 and 2A or code 7 in box 7. Will you correct this with the IRS? Okay, how many of you have had this question? I know I get this question on a regular basis here. Why is my QCD showing up as taxable? It shouldn't be, so you have to change reporting for it. So can you change reporting? Very good. We report qualified charitable distributions like any other distribution from your IRA after age 59 and a half, which is a code 7 normal distribution. We do not report it specially. It is up to that IRA owners to make sure that they do it. According to the instructions for Form 1099-R and 5498, there is no special reporting for qualified charitable distributions. The Form 1040 and 1040-SR explains how you make sure you claim that distribution as a QCD on your tax return. So look at this here. It says specifically on the forms 1099-R and 5498, the instructions for those forms, there is no special reporting for qualified charitable distributions under Section 408D8, qualified health savings account funding distributions described in Section 408D9, or for the payment of qualified health insurance premiums for those retirement public safety officers. There is no special reporting, very specifically there at that tip, the very top part. Exception 3 is coming from the 2019 instructions for Form 1040. It is on page 24 of it. It says, if all or part of the distribution is a qualified charitable distribution, you should enter the total distribution on line 4A. If the total amount distributed is a QCD, you will enter 0 on line 4B. If only part of the distribution is a QCD, enter the part that is not a QCD on line 4B. Why 4B is telling you what's taxable. So by entering 0, you're saying this amount is not taxable. You also need to have QCD next to the line 4B, letting them know why the rest of it's not taxable, why that distribution amount either doesn't line up or why we're saying it's 0. It also goes into detail giving you information about what a QCD is and how you must do it moving forward. That it has to be made directly to the trustee of your IRA, to an organization eligible to receive that tax deductible contribution. You must have been at least 70 and a half when the distribution was made too. So we can't do it prior to 70 and a half. IRA owners and beneficiaries can do this, but you both have to be 70 and a half in order to do this. The second part on page 24, the third picture, is a continuation explaining the rest of the QCD rules, letting you know that you can't do more than 100,000. On a joint return, your spouse can also have a QCD of up to 100,000. So you can technically do 200,000 if you and your spouse are doing one. The QCD is limited to the amount that would otherwise be included in income. If your IRA includes non-deductible contributions, the distribution is first considered to be paid out of otherwise taxable income. So you can't claim a charitable contribution deduction for any QCD not included in your income, okay? That is an important part. So you can't kind of double claim that. Makes sense, right? It's before the tax filing deadline, and I realized that my tax rate is much lower than I expected for last year. Can I convert money from my traditional IRA to a Roth IRA for last year if it's before the deadline? In other words, can I convert money in a different year than what I want to claim it? Very good. Unfortunately, there is no ability to do a prior year conversion. Like there is with the regular IRA contribution. So where you can do a prior year contribution, we can't do a prior year conversion. The distribution from the traditional IRA is what triggers the taxation on the conversion. Treasury Regulation 1.408A-4 goes into detail on this, talking about, it's question and answer number 7. What are the tax consequences when an amount is converted to a Roth IRA? It says specifically, any amount that is converted to a Roth IRA is includable in gross income as a distribution according to the rules of Section 408D1 and 2 for the taxable year in which the amount is distributed or transferred from the traditional IRA. Thus, any portion of the distribution or transfer that is treated as a return of basis under Section 408D1 is not includable as gross income as a result of conversion. Here's another thing, according to publication 590A, page 45. You must include gross income from a traditional IRA distribution in the year you converted the assets, as if you hadn't converted the money. So in other words, as if you kept the money yourself, you have to include it in income there. You must include in your gross income distributions from a traditional IRA that you would have had to include in income if you hadn't converted them into a Roth IRA. These amounts are normally included in income on your return for the tax year you converted them from a traditional to a Roth IRA. So there's no way to make it count for a previous year. Counts in the year you distribute it. That's it. You're done. Here's 2 sources here to make sure that you can kind of back that up and show them that there's no information, no way to allow for them to do that. My brother and I are the beneficiaries of our dad's IRA. Dad didn't take his Rmd this year, the year that he died. Which one of us is responsible for taking it? And guys, if you're not able to copy down all this information, don't worry, it is in that exercise master at the back. The exercise master, page 5, if you're looking for it. And it goes over all of these answers. So don't fret that you're not getting everything copied down. Okay? All right, the answer to this one. Because your dad's IRA had multiple beneficiaries, the remaining Rmd will be split between the 2 of you as the named primary beneficiaries, based on the percentages that your dad listed on his beneficiary designation. Both of you are responsible to ensure the year of death Rmd is paid out in the year of death. So if you split this 50-50, you had a $1,000 Rmd that was required from your dad. Technically, both of you should take $500. Question you get asked regularly is, what if one takes $1,000? Does the other still need to take $500? Well, technically, you were supposed to split all of the money. Therefore, you would be technically supposed to split the responsibility, which the responsibility is each of you taking $500. Therefore, that's why we say this. As I mentioned earlier, this is a huge controversial topic. A lot of people say that as long as $1,000 is satisfied, you're good to go. Is this something that the IRS is ever going to really look into? Probably not just for this purpose. I would say it might only come up if they're auditing an account for other reasons, you know, but that's still a chance out there. And it's always one of those things, like, better to do, to the best of your knowledge, what they're wanting from you than just what you want to do, honestly and truly. But I'm always make sure you're on the safe side of things there. Our proof on this one is not only Treasury Regulation 1.401A95, but it is also publication 590B. In this publication 590B section, it talks about the distributions in the year of the owner's death. The RMD distribution for the year of the owner's death depends on whether the owner died before the required beginning date defined earlier. If the owner died before the RBD, there's no required minimum distribution in the year of the owner's death. So technically, if they hadn't taken that distribution yet, and they hadn't hit April 1st of the year after the year they were required to take in, there's no RMD due for those beneficiaries because there wasn't one due yet for the IRA owner. If the owner died on or after the required beginning date, the IRA beneficiaries are responsible for figuring and distributing the owner's required minimum distribution in the year of death. The owner's required minimum distribution for the year is based on Table 3 in Appendix B. And then it goes into explaining when we might use a different table on that RMD amount. So note, it does say the IRA beneficiaries are responsible with. So it's saying not just one of the beneficiaries needs to take it. It says beneficiaries. So if there's multiple, we need to make sure they take that. It's one of the things we hang our hat on, as well as that 1.401A9-5 there. Question number 7. I made a 2021 contribution in February 2022 that turned out to be an excess contribution because I didn't have any eligible compensation for 2021. I've already filed my 2021 return. Because it's before the 2021 contribution deadline, can you fix your reporting to show the contribution as a 2022 contribution instead? So what do you guys think? Again, it's kind of asking, can we change what year that it was designated for? What do you think here? Very good. All right, so because you designated a contribution for 2021, we cannot change the year for which the contribution was made. So like the others, we're stuck with noting that it was made for the previous year. However, we do have the ability to do a removal of an excess, right? Because technically in this case, they were ineligible to make this contribution. They can remove that. We may still remove a 2021 contribution as an excess if done by your tax return due date, including extensions. You will, however, need to amend your tax return to show this excess correction. So on our side of things, though, what we will do is we will have a 1090 or a 5498 showing that the contribution was made. It was officially made, so we can't cancel that the contribution was made for 2021. But what we can do is we can have that 1099-R showing that an excess was removed, and we've corrected that in 2022. And that's how that IRA owner is going to need to make sure that this correction is addressed, that they tell their competent tax advisor to help them make sure they show an excess contribution occurred. According to publication 590A, if you file your taxes timely, you have an additional 6 months after your tax filing deadline, including extensions, to remove the contribution. You also will need to file an amended tax return, report any related earnings, and include an explanation of the withdrawal with your tax return. The way I like to remember this one is with excess contributions, when you get that additional 6 months following your tax filing deadline, so that additional 6 months going to October 15th, you have to make sure you're on the IRS's good list, not the naughty list, right? So individuals that are subject to that 4/15 deadline or the tax return deadline, hard there's no excess removals following that time period, are going to be the individuals on the IRS's naughty list, those people who didn't file their taxes timely. And not only that, but they didn't file an extension. They didn't let you know, hey, I'm not going to make it timely. What do? They didn't do that. If you did file taxes timely and you did provide for an extension, request an extension, you're on the IRS's good list. They're happy with you. You get an additional 6 months to do anything you may need to do because your taxes told you you needed to do it. Oh, I didn't realize I didn't have enough income for it. I need to remove that excess there. Okay. Notice that there is an additional line there at the bottom that this doesn't go up at the top. It says make any other necessary changes on the amended return. For example, if you reported the contributions as excess contributions on your original return, include an amended Form 5329 reflecting that the withdrawn contributions are no longer treated as having been contributed. So we need to make sure we amend everything. What is this doing? It's kind of taking us back to try to erase what happened. Will we ever completely erase it? Will it ever disappear from that 5498? No, it will always be on there. But you can do the steps to make it to where it doesn't affect you moving forward. Fortunately, amended tax return is just part of it on that one. Last week, I took a $10,000 distribution from my IRA. I would like to roll over $6,000 today and $4,000 in 4 weeks. Can I do that? Or do I have to roll over all $10,000 at once? I've never taken money from my IRA before, so I'm not sure. So what do you guys think? Very good. Getting a couple right answers flowing in here. What do you guys think on this one? You guys are right. You can roll over part of the IRA distribution and part of the distribution later, as long as both amounts are rolled over within that 60-day from the day following you receive the distribution. Because you have not received an IRA distribution that was rolled over in the last 365 days, this will not violate the 1 per 12-month rule. How do we know this information based upon what the IRA owner said? Well, they said they'd never received a distribution before. So obviously, if they've never received a distribution, they've never rolled over one either. So we don't have to worry about that. It would be their first one in that 12-month period. This is according to IRS Publication 590A, based on the distribution. It gives information on that 1 per 12-month rule and says specifically that it's only one distribution in a 12-month period is allowed to be rolled over. It doesn't say it has to be done in one rollover contribution. So you generally must make the rollover contribution by the 60th day. That's your time limit for making it. The waiting period is going to be making a tax-free rollover of any part of a distribution from a traditional IRA. You can't, within a 1-year period, make a tax-free rollover of any later distribution from that same IRA. So see, all of this here we're talking about keeps referring to distributions. You can't do it of the distribution. It doesn't say anything about contributions being multiple contributions in. It just has to be done in that 60-day time window. And our last question here. I have a 401k plan that allows my required minimum distribution to be delayed until retirement. Can I roll over the entire plan balance in October 2022 if I'm going to retire in December of 2022? Very good. So think about it. Your RMD is technically delayed until retirement, but it is the year you retire that's considered when your RMD is due there. So, no, your retirement year is considered your first distribution year. So you would have to receive your RMD and then roll over the remaining eligible assets. Certain 401k plan assets are eligible for rollover treatment. RMDs are not one of them. So because you later retire in that year, the first money out is going to be considered your RMD, even if you took it prior to retiring, because that's considered your first distribution year. So any money taken out that year is going to count towards that RMD. Therefore, if you rolled it over, it would be an excess. You're not allowed to roll that money over into the account. There are several Treasury regulations that back that up over here. You can look those up for more information. These are the sections in publication 560, specifically showing that RMDs are specifically excluded from the amount of the plan balance that is eligible for rollover treatment. And it does go into detail about that. Since we are on the topic of qualified retirement plans and RMDs, I do want to mention one more brief thing. We talked about how we could aggregate RMDs amongst IRAs. We can't aggregate RMDs between qualified retirement plans and IRAs. So if you have an RMD due from a qualified retirement plan, you have to take it from the qualified retirement plan. The IRA RMD can't be taken from the qualified retirement plan either. So these are important things to remember there moving forward. As I mentioned, here's all the ones that are not eligible for rollover distributions, and it does say a required minimum distribution right here. It's not eligible for rollover. You guys made it to the end. Are there any questions regarding anything we've gone over today? In the meantime, while I wait for questions, I want to thank you all for attending the seminars. I hope you enjoyed them and you got something out of it. I know that today is a lot heavier of a subject and a lot more information to kind of grill down on moving forward, but I hope you still at least semi-enjoyed yourself moving forward. These are also a few other items that a census does. We are a processing and administration. We do that. Forms and documents, compliance support, as well as staff training and development. You should be receiving a survey asking how you liked it via email at some point in time. If you felt like it was good, please give us a review. We'd love to get information and feedback on our training materials and what we went over today. Is there anyone that thought of any questions while I was giving my spiel here at the end?
I do have a question, but it's not exactly related to what we went over today. Maybe there's guidance on the census site, or if you know about retention regarding keeping paper documents once we have a digital image.
So the big thing is you're going to need to be able to recreate that. If you can recreate those files and you have that as a form of digital image, then that should satisfy most of those requirements. Now, there are documents that they do like you to go ahead and keep on file. And I do believe there's actually an article regarding that on our website, like you mentioned. So let's look here.
And in addition to that, some documents, for instance, anything we use DocuSign for, would never have a paper copy in existence ever.
Correct. Yep. Mm-hmm. It's not going to show. Yeah, and a lot of things are going over to DocuSign now, so I think that's why it's just kind of becoming an obsolete thing. As long as, I know it's very specific stating, as long as you can recreate that, that is the most important thing there in regards to that. This is probably going to bring up too many options here. What I might have to do is I might have to see if there's an article available that goes through everything, and then send it to Stephanie, and she can send it out to you guys if that works with you, Stephanie.
Yes, absolutely.
Perfect. All right, I will see if I can locate an article that goes through it. If not, I know we talk about it in our compliance manual. So if you do have our compliance manual, that would go over it in detail there. And I'll note what page number on that in my email that I send over to Stephanie too, in case you want to review it on that. You do have the compliance manual and everything moving forward there. But the big thing that the IRS wants with record retention is, as I mentioned, they want to be able to come to you and say, I want to see everything on this IRA owner. Make me their file. Show me what it is. They don't care necessarily if it's the actual original signed information. They just want to be able to see that it was signed and that you have that information. So if you can print it off that digital copy, that will satisfy almost all requirements there.
Thank you.
Any other questions?
I do have a question about the CE credit. For those of us on the call that can use the CE credit, how do we go about getting that from you?
Stephanie, I think that's a you question, right?
It is, because I do not have all of the names, because I know that you, there are a number of banks that have more than one person in your training rooms for CE credit. Can you just shoot me over an email and I'll put it real quick into the chat? So I have your name correct, spelling and everything.
And then do you need like our CFP number?
Yeah, let me know what it's for. Yeah, CFP, I have to report that on your behalf.
Yeah, I think the last one I did was the full name and the CFP identification number, and then the designation. So CFP basically.
That's great. Yep.
Okay.
Any CTFAs on that's self-reported, so you can go ahead and do that on your own.
Okay, so sfisher@mibankers.com.
Correct. Yep. And then certificates of completion, we will email those out as well.
Thank you.
Yeah, you're welcome. All right. Any more questions for Elena before I take over?
It was nice getting to know you all, and I appreciate all of you talking and giving feedback as we go throughout. I hope you enjoyed it. And like I said, I hope it wasn't too overwhelming for you guys moving forward here. So have a wonderful week and a great weekend here. Stephanie, it's all you.
Thank you very much. Great couple days. Appreciate all your assistance, and well done. And thanks to Census as well. Just to recap real quick, I'll email the SurveyMonkey out along with the recording. I did just put it in the chat too. And then you can just respond to that email if you'd like, if you needed CE credit, and then we'll email a certificate of PDF. So thanks everyone, and look forward to seeing you again really soon. So stay warm. Thanks, Elena.